Howdy, howdy, late callers. How call are you lating? How late are you calling? You want a coffee? Has anyone got a coffee for me? I could have done with getting a coffee right now. Me, but I'll have to go and get one in a few minutes. I was held hostage. I was held hostage and beaten to within an inch of my life. And I finally figured out what Katie says on the coffee call, right? On the coffee call, Katie Magbanua says, fucking A, bro. I'm gonna fucking fuck up whoever the fuck is fucking with me. I'd never really put it all together before. I'd never pieced it out. But yeah, today we're going to be wrapping it up because the state rested, the defense rested, the cases are closed. Now that's all that's left to do is for the parties to combine with the judge, talk to the judge, and come to some, agreement between all of them of how the jury instructions are going to be read out. And I realize that might sound a little dry. Judge, where it says Katie should be not proven beyond a reasonable non-doubt. I think it should say non-doubt should be without proof of no Katie innocent bagua. So we're going to have a look at that and see what's going on. I mean, we'll call it. We'll call it if it's real. I think it's interesting. Maybe you will too. Um, but yeah, maybe it's going to go on for a little bit, and then we want to get to the meat and bones, right? We want to get to the meat and bones of the video, which is George's closing. Then Tara's closing. Then one hell of a brutal rebuttal from Georgia Kaufman. I mean, it should be called a rebrutal. The rebuke, the rebrutal rebuttal. It really is a slap in the face to Christopher DeCoste and to Tara Kawas and whoever that third person is. I know it's the sister of, but we just never learn her name, do we? Well, maybe we will because she's about to do some talking. She's the stickler. She keeps telling the judge that she's a stickler for details. And she is. And maybe that's how they're going to win the case. I don't think so. But just wait until you see how Tara Kawas opens this conversation with the judge, guys. The judge is going to say, oh, do the parties have anything to say, anything to raise before we move on to finalizing of the jury instructions before deliberations? Of course, Tara Kawats comes to the podium and starts saying, yes, we'd like to renew all motions, and I think it is safe to say that no reasonable jury member could ever find Katherine Magbanua guilty of anything. I mean, literally, I was watching it a little bit earlier, and she starts to sound like deranged. Like we need to get this woman into care quickly before she starts eating her own feet. You know, it's like, what? Are you okay? Are you okay? Are you on the same planet as us? Because what were you watching? It just doesn't come. I think part of it's her whole sort of chirpy atmosphere of a personality. It's like, okay, you're definitely fun bag mental. Take your meds in front of me. You take those in front of me. You know, let's check it out anyway, guys. Welcome everybody in chat. Is it a quiet night? Is it a quiet night? A busy night? I don't know. Thumbnails rubbish, but it could be worse. I wish I wasn't blocking George's hands, those beautiful hands, those hands of justice. Beautiful hands of justice. All right, let's check it out. Quit fucking around. Enough dollars in your pocket. Let's go.
Yes, Hannah. At this time, the defense would like to renew all previous motions and objections and now make our second motion for judgment of acquittal.
Okay.
Even in the light taken most favorable to.
All right, I can already tell that I need to turn that up considerably. So I can make this happen right now. We might have a double Metrix watermark in the bottom right hand corner. I know some people find that annoying, but we've had to put this together in a real rush tonight. Let's turn it up to 180%. We like 180%. That 180 is the new 100. Okay. 72. 80. 180. How's that?
The state, I think the standard is now that no reasonable juror could find Ms. Magbanua guilty beyond and to the exclusion of every reasonable doubt. Now that the standard has changed, Judge, a little bit, and we've also had evidence from Mr. Connell, I would rely on the same arguments I made as to the elements of all three charges, in that all of the case is circumstantial but for the evidence of Luis Rivero. And now that Ms. Magbanua has taken the stand and explained everything as it relates to the circumstantial evidence in this case, and she's been consistent since day one, that weakens the evidence against that the state has as it relates to the circumstantial evidence. And then now all you have left to evaluate is still Luis Rivero. Same argument, Judge. All we have in front of us is Luis Rivero, who admittedly says, I don't know anything about this. I don't know who did the hiring. I don't know anything. It's only Garcia's telling me that Katie is in the one doing the middle. There's no evidence that she knew what in the middle was for. Was if you believe him and he says, oh, she was in the middle hiring us for this, Luis Rivero himself says, I thought I was going to commit a robbery. And the elements say that you have to have intended the crime to be committed. There's no evidence that Ms. Magbanua conspired with anyone to have a murder committed. Mr. Rivera was not able to give any information as to who it was in the Adelson family that this was done through. Ms. Magbanua didn't do anything to assist. There's no evidence that the paperwork with Dan Markel's face on it didn't come directly from Charles Adelson. Mr. Rivera never said that that information came from Ms. Magbanua. It actually came from Mr. Garcia. And the only evidence they have is supposedly her the next day being picked up by Sigfredo and going to the house, and their own witnesses say that she didn't know what was in the bag. Even believing that that took place, there's no evidence to establish that Ms. Magbanua knew there was money in the bag or that this was money for any criminal activity. So in addition to all the cases that I cited earlier, Judge, for my first JOA, this is the additional argument that I'm making for the second JOA.
All right, thank you, Ms. Kwas.
Thank you, Judge.
Ms. Kappelman.
I'll rely on my previous arguments, Your Honor.
All right, the second motion for judgment of acquittal is denied. There is sufficient evidence for a reasonable juror to find the defendant guilty on all three charges.
Yeah, nice try, Tara. I mean, God, doesn't that sound deranged? The only evidence is circumstantial evidence against Katherine Magbanua. There is no evidence that she knew a murder was going to be committed.
There certainly is sufficient evidence for this to go to the jury, and for my reasons also stated previously, the motion is denied. All right, can we take a look at the jury instructions now? I think we can get through these pretty efficiently so that we can have them ready to go when we bring the jury back tomorrow. So who's going to handle this on behalf of the state?
Mr. Evans is going to come down, Judge, but I'll stand in until he arrives.
All right. And do you all, Ms. Dugan, do we have the same technology that we have out in Gadsden where we can make changes to them right here?
Yes, sir. I can make changes as we
Okay,
go.
can you do that? All right.
Good morning. Good evening, Your Honor.
All right. Good afternoon. Good late afternoon.
Late afternoon.
All right. And so, Ms. Kwas, you're handling.
I love that touch. You know, because if it's just gone 12, it's like, okay, you said morning, and it was morning 5 minutes ago, but now we're late afternoon. It's not been morning for 4.5 hours, okay? Get with the program. I thought you were the stickler. You're the stickler for details. You come in at 4:30 in the afternoon saying, good morning, Your Honor. Yeah, I can see. You're so stickly on those details, aren't you?
The
Yes,
jury
Your Honor.
instructions? Okay.
No.
God, look at Katie Magbanua. She's about to fucking fall off her chair. It's like she's just ran 2 marathons in a row. She's literally just come off the stand for her whole testimony. Direct, cross, and rebuttal. Brutal. Oh, we caught Tara looking right at the camera there. Look. Oh.
Afternoon.
Late afternoon.
All right. And so, Ms. Kawashi, you're handling the
Yes, Your
jury
Honor.
instructions? Okay.
No.
I could have just a moment to pull them up.
All right.
Your Honor, I just want to let you know it's very minor changes. A lot of it really just includes taking out some instructions that the state included.
Okay.
And
All right.
I'm a stickler for mirroring the language from the Florida Supreme Court's
All right.
standards. So it's
I
just
appreciate that.
relatively minor changes.
What I'm going to do is, since the state submitted them to me, I'm going to take it as if they don't have any objection to them, and so I'll be going primarily to you to see as we work our way through to see
Right,
if
Your
you
Honor,
have
and
any
I have the
objection.
copy that they provided to you, so I've been going based off of their copy and the minor changes that I
All
wanted
right,
to have
thank
made.
you. We'll let Ms. Dugan bring them up, and then she can just make the changes there, and then we can get the appropriate copies made for tomorrow.
I'm ready.
You ready?
Yes, sir.
Okay, the only thing that I see on the first page is just a minor change with, there's no space above justifiable homicide on my copy. If you could just make sure that's a space there.
Well,
All right?
Yes, sir.
And then also on the bottom, it's the wrong, I don't know what those are called on the bottom there, but can you see underneath the page number? It has Mr. Garcia still on there, so we need to take that out
yes.
for the page number.
I didn't notice that.
Okay, so for the statement of charge, introduction to homicide, and the justifiable homicide instruction, and the excusable homicide instruction, those are standard instructions. Any discussion on those?
Yes, Your Honor. Just like I said, I'm a stickler with the Florida Supreme Court's guidance. So in the statement of the charge, I would just add that conspiracy to commit murder and solicitation to commit murder is just the addition of those words instead of
Conspiracy to commit murder and
Right,
solicitation to commit murder.
Right.
All right, I'm in favor of that, so we'll just make that more
Yeah,
specific.
it's just more clarification for the jury.
Conspiracy to commit, solicitation to commit.
Right, to commit
Conspiracy to
murder.
commit murder and solicitation to
Just
commit
as how it's
murder.
charged in the information. Just to add those words.
Tara's co-counsel is Christopher DeCoste, but this lady is like the document lady, and I think it's her sister, I believe. Is that correct? You know, I've heard that a lot. I've never verified it. I don't know her name, and it could be different than Kawas because she could be married.
I just want to make sure that our camera here is not getting any work product by looking at the back.
Yeah, they do, don't they? They look like the band in the Robert Palmer video. Well done, V. Shaw.
Okay, thank you.
Your Honor, as for the introduction to homicide, we would ask that the first 3 paragraphs.
Hi, Jane.
We are the defense is waiving all lesser included. In this case, we believe that based on the facts, we've never disputed that a first-degree murder has been committed. So we would be waiving all Category 1 lessors. We would ask that second-degree murder not be included, manslaughter not be included, any lessors of murder. We're not disputing that Dan Markel was premeditatedly murdered.
State is not waiving the lessors, Your Honor.
All right, we're keeping the lessers. That's a standard instruction, so we're keeping in both the second degree and the manslaughter.
Okay, Your Honor, we're not asserting justifiable homicide or excusable homicide. We would ask that those be taken out.
I think those are required.
How can you possibly? How could they say it was second degree? The very nature of a murder for hire is premeditation. You know, how do you make that manslaughter? We planned to kill him, but it was an accident. We planned to kill him. We went round there, but we changed our mind. But due to carelessness, we bumped into the ladder he was climbing on our way out after we changed our mind. So manslaughter. What? How? Why would you have manslaughter and second degree murder as lessers on a murder for hire plot? I don't get that.
To be read, Your Honor. And so we are requesting them.
All right, I'm going to keep them both. It's a standard instruction that's given in every first degree murder case, and so they will remain. All right, so now we go to.
I love how she put it though. She was like, "Yeah, the defense is waiving this. We waive our rights to have the lessers because she doesn't want them there, right? Because the thinking from the defense point of view is if the jury are only given first degree murder with no lessers, no possible lesser charges as an alternative, and they can't get over the line of first degree murder, they haven't got second degree to fall back on. And in Florida, that's a life sentence anyway, maybe with parole, but after a very long time. So it's basically the same in punishment wise. But I still don't get how you would land on second degree or manslaughter from a murder for hire situation.
Count 1, first degree murder, and any discussion on that, Ms. Kawaz?
No, Your Honor, I have no objection to the actual where it
It is coerce. Okay, so it is sisters.
says count 1 first degree murder. I have no
Okay.
objection to it's the
All right.
standard jury instruction.
And then the standard instruction with the lesser included crimes, I understand that you have an
right.
objection
Right.
to including them, but that's the standard instruction if we
Right.
are. Okay. All right. And then second degree murder, any discussion on that?
No, Your Honor.
Okay. And any discussion on the manslaughter?
No, Your Honor.
All right. Thank you. Okay. The principal's instruction, any discussion on the principal's instruction?
Your Honor, I know that it was probably just put in there just to facilitate everything for the jury, but the way it starts with there are 2 ways in which a person may be a principal is not in the standard jury instruction. We would just ask that it read principles, and then that language is taken out, and it starts with if the defendant helped another person, which is the standard language. I do note that it says if the defendant helps another person or persons commit a crime, it says that defendant. I don't know if that's maybe just because Ms. Magbanua was tried with Mr. Garcia the last time. The standard language says the defendant, not that defendant. I know I'm being particular, but I'm just, like I said, Your
All
Honor.
right. Then no, that's whenever it's clear, I don't have any problem with
Right.
the
So, and then the rest of the paragraph is fine. And then it says the first number 1, it says that defendant. I would just ask that it be changed to the defendant. And the same for paragraph 2. So instead of that defendant, it says the defendant.
All right.
The language otherwise is standard.
Okay. All right. So there are 2 ways in which a person may be a principal is not in the standard instruction?
No, Your Honor, because the standards are differentiated between 8 for
Okay.
principals. The second one would be
Okay.
principals, and then it says when active participant hired by defendant. That would
All
be
right.
the second principal instruction.
Mr. Evans?
Your Honor, the reason it was being requested for both, this line was inserted the last time and it needs to be inserted this time, is because there's 2 ways to prove principles. One is the first paragraph, or the first one that goes through if the defendant helped another person, and goes through 1 and 2.
All right. I think it's repetitive. I don't think we need it. I mean, if you read it all in its entirety, that you can tell that's what the jury instruction says, that there's 2 ways. So we're going to take that out, Ms. Dugan. And then if you could change.
Wow, look at Sarah's hair there. That's amazing. Looks like a member of Guns N' Roses. It's Axl Rose. Welcome to the jungle.
That.
You don't get hair like that without jungle level humidity.
On that first line to the, and then also with 1 and 2, change that to the. If you have any question about what I'm saying, then let me know. Okay. And then on the next way to be a principal, where it's 1, 2, 3, on number 1, we'll need to change that to the.
And also, I believe in the initial paragraph, I have it here as an addition. I think it might have been inadvertently left out. It just says defendant instead of the.
Left out. Yeah, that's all right, Roberta. Listen, I have got to go and get a coffee, guys. I know I should. Well, I just didn't have time. I'll be back in 3 minutes.
Defendant. And Your Honor, I'd just like to note for the record that the first line of that paragraph where it says the defendant may also be a principal if he or she is not standard language, it just starts, the standard language starts with if the defendant paid or promised to pay another person. That's how the standard reads.
All right.
The may was instructed for the same reason the first line was instructed, to differentiate. There are 2 ways to prove principle, which is the first part, which would be 3.5A, I believe.
It's A and B.
Yeah. 3.5A. And then the second part is the second way you can prove a person is the principal is 3.5B, which is where it starts the defendant paid or promised is what it says. But the reason that line, the first part of that line was inserted, it was inserted last time, was to.
I don't care if it was a certain last time. I don't need to
Well,
hear
Ju-
that. Is
well,
it in the
Judge-
standard instruction?
It is not standard instruction.
Then I don't
in the
want
re-
it. I don't want it. The defendant may also be a principal is struck. And so if, it'll start with if.
If the defendant, right. And Your Honor, I'd just like to note in element 1, it says that defendant again, instead of though.
And Your Honor, for the record, the reason the state has made this and is requesting is an obstruction and is objecting to removal of it is that it needs to be clear to the jury that there are two ways to prove the defendant may be a principal. One is under 5A, the other, or 3.5A, the other is under 3.5B. And the way it's being worded now does not make it clear to the jury that distinction, that there are two different ways.
Your Honor, if I may respond, I believe that how that could be clarified is where you have principles, which is how the 3.5A is titled principles. 3.5B is actually titled principles when active participant hired by defendant. I would ask that that title be included before the second one so that the jury is well aware that there are two different ways that principles can be proved.
Would not have any objection to that, Your
Yeah.
Honor, because then it clearly makes
It's
distinction
different.
there are two ways.
I agree with the state, Your Honor. I don't want to
All right, well,
compound the two.
make that change then.
Sarah, it would look like this.
Right.
So it would just be the title of the actual 3.5B. So take out this language here that says the defendant may also write. And then, so that would be capital. And then you can add in this title, which says principles dash when active participant, because I understand that the state wants to differentiate the two. So it would be that title, but with a hyphen right before the second one. I don't know if you want to include in the standard. I know it's repetitive, but after both principles, it says to be a principal, the defendant does not have to be present when. I don't know if you want to have that.
Okay, hold on a sec. If we need to get this on the record.
Okay, Your Honor, if the court agrees that we should have them differentiated by title under the first principles instruction, the standard language, and it's repetitive to both principles, but I want to make sure that it's clear to the jury for both. After the second element on the first principles, there should be language that reads, to be a principal, the defendant does not have to be present when the crime is committed. That language is read for both principles instructions. So it will be repetitive, but since we're delineating them into two different types of principles, I'm sure the state would agree that that line needs to be read
so Mr.
more than
Evans,
once.
is that a distinction? Is that a good enough distinction for the state?
Yes, well, since we're breaking the two of them out, they should read and put them under different headings.
Right.
They should read as the standard instructions read. It does include that line, so we have no objection
Right.
to it reading
All
as
right.
the standard read.
Thank you.
I know that. Everything's fine. The only thing that's changed is in red.
Yeah, I know, I'm looking right here now.
Okay,
And then
sorry.
I've got a V lowercase there.
Oh, and Your Honor, in paragraph 2 under 3.5B, which is when active participant, I would request that it cross out he or, because it reads he or she, but in this case, Ms. Magbanua it's just Ms. Magbanua alone.
That's acceptable, Your Honor.
All right.
Yes, please. Yeah, that line needs to be put in right above. Huh? Oh, yeah, in both paragraphs, this line has to be. Oh, yeah, we have it in this one. Right.
Yeah, in both paragraphs, it'll
Both
just say if
paragraphs have-
she.
Right.
Oh, okay, so I'm just gonna copy and paste this then.
Well, yes, that needs to, and then in both paragraphs,
All right, I'm just gonna copy and
oh,
paste that.
right, in here at the top, if she, as if she. So right here, just cross out he or, because I remember last time Mr. Garcia was sitting.
Okay.
Right.
All right, just look over that real quick. There's a lot of change.
Just make sure.
Do you want to get over to?
Yeah, here, I've just made my changes in red.
Yeah.
So the, and then the defendant, and then the language, the standard, right. And then it starts with, it's the defendant, right? The person's separate.
Hello.
In the 3.5B, the active participant, in the state's version, it's broken down into two separate sentences. It's actually just one sentence. So it says, if the defendant paid or promised to pay another person or persons to commit a crime, comma, the defendant is a principal and must be treated. They have it as two separate sentences. So I would just ask it if the state has no objection, just to
No objection.
have it read
To read it.
as
Yeah.
one fluid sentence.
All right.
Oh, you want? Okay.
Yeah.
So it would be crime.
Straight from Coachella.
So it'll be comma and then
It
a
would be
lowercase
comma
t.
the defendant, and all the language is the same after that.
Yeah.
Okay. And then and the line. Okay. You go. Yeah. Okay.
All right. The changes have been made?
Yes.
Okay. All right. So now we're to independent act.
Your Honor, we were asking to remove that instruction. I did some case law, and I found case law that says that when the defendant's theory at trial is supported by the testimony at trial from the defendant, is that they're denying any involvement, it negates the propriety of an independent act instruction. And I could put the case cite on the record.
All right. Mr. Evans, any objection?
No objection. If it was put in there last time, I think at one of the defendant's requests.
I
Right.
think it was Mr. Garcia's
Okay.
request, yeah.
So we'll take out independent act.
Yeah.
Count 2 for conspiracy. Any discussion?
Your Honor, the only language that's not standard is the first line that says, in count 2, Katherine D. Magbanua, the defendant in this case, has been accused of the crime of conspiracy to commit first-degree murder. That's the only language that's not standard. I mean, I don't.
All right. It's just the introductory line. We'll
Right.
keep that in. Okay. So everything else is standard. You're okay with it?
Yes.
Okay. Mr. Dugan, you're all caught up?
No changes.
changes.
No
So no
changes for
objection.
conspiracy.
Yes, I am.
Okay. All right. Count 3, solicitation. It has the same introductory line.
Right.
And then any other discussion?
Yes, Your Honor, the amended information for the solicitation count actually lists who the one or more persons were, so I would ask that it track the language of the information. So we would take out the defendant solicited one or more persons and put in the defendant solicited Luis Rivera and or Sigfredo Garcia, because that's how it's charged in the information.
Do you have any objection or do you have discussion on that, Mr.?
Sigfredo Garcia.
Do you want me to pull up the information?
So they want the specific names of,
Yes, that would be acceptable. Your
And
Honor.
that's exactly how it's worded in the information, Your Honor.
all right.
it would read-
So the defendant solicited,
Luis Rivera and or Sigfredo Garcia.
all right.
That's how it's charged in the information. And that would
Luis
also go for the second
Rivera
element.
and slash or,
Yes, and or. So, yeah. I hate that language in jury instructions, but that's how it's charged in.
Sigfredo Garcia.
Right. And that would also go for element 2, Your Honor. Where instead of one or more persons, it would say Luis Rivera and or.
All right, you see that, Ms. Dugan?
Yeah.
Okay, let me know when you're ready. Okay. Plea of not guilty, reasonable doubt, and burden of proof is the standard instruction. Any,
Listen to this. Nancy is saying, "Hi all. I'm following on the sly while at a family event." Well, I hope it's not a funeral. What kind of family event is this? Show some respect.
discussion on that?
Like I said, Your Honor, I don't mean to be a stickler. I just like to track the language. It says to overcome the defendant's presumption of innocence, the state has a burden of proving. The standard instruction doesn't pluralize.
The standard instruction. Let's give the standard instruction on Julia's question. How is Soap doing? Yeah, she's okay. She's fast asleep. I think she was up all night, sleeping under the table. She couldn't get on the bed, and she's been a bit spazzy today. She's been yelping in pain, which is horrible to hear. I'm sure people know what that's like. But I couldn't find anything that was. I touched her all over, and I couldn't find anything that was like causing her pain. It was just this weird thing, and she's been like confused and just a mess all day. But she's eating, she's drinking, she's going to the bathroom, she's not vomiting, and she's active. If I take her out around the fields over here, she's fine walking around, and she's happy enough to do so. So I thought I put on Discord, I was like, I think it might be something like, what did I say? Muscular, like a cramps or something, And then vet tech Amy came and said, oh, yeah, because she had a vaccine the other day, sometimes there can be, muscular, what was the word? Spasms or something. So that adds up. That really checks out. And yeah, she's all right. I think she'll be fine in a day or two. But thank you, Julia, for asking. She's okay.
Crimes, it just says crime, with which the defendant is charged was committed, and the defendant is the person who committed the crime. It's mere semantics, Your Honor. I mean, I doubt whether it says crimes or was or were or individual or person would really have an effect on the jurors. I'm just a very big stickler for tracking language for the instructions.
I'm a big stickler for people that keep saying how much of a stickler they are and get the fucking say good morning at 4:30 in the afternoon. That's what I'm a stickler about.
All right, so do we want that in plural then, since there's 3 crimes charged?
That was the reason it was included, Your Honor.
All right.
For crimes charged.
And the defendant is the individual who, so then it needs to be consistent with the last crime on that paragraph. Has the burden of proving the crimes with which the defendant is charged were committed, and the defendant is the individual who committed the crimes.
Okay.
Right.
So right here.
Got it? All right, then we go to weighing the evidence.
Judge, everything is exactly as worded. I would just ask that the 10th factor be considered, which was, does the witness have a general reputation for dishonesty? And I would be pointing to Mr. Rivera.
I don't know if reputation was admitted in this.
Your Honor. Yeah, I said, well, Garcia and Rivera, several witnesses, Your Honor, were asked about Mr. Rivera's reputation. Was he known as a Laughing King member? Which I would.
All right,
Wendy
out
as
of an
well.
abundance of caution, we'll
Yeah.
put that back in.
And Miss Adelson, of course. Which
So
would
do you know that
possible.
language, Miss Dugan?
Sure, did you hear what I just said? Yeah, she's okay. Just muscle spasms after a vaccine that she had on Thursday. I'm sure she'll be fine.
Yes.
So let's see, we keep it. All right, so we're adding number 10.
Right. I think it's 3. I can't remember, but I do have the actual.
Hi, Brian, and thank you, DJ Miller, for the super sticker. Nice one, DJ Miller.
You got the actual.
Yeah, actually, I have this. I tracked
Okay.
it. You can double check it before you submit them tomorrow, and I tracked it from the website. And the rest of that instruction is perfectly fine.
Okay, we keep in law enforcement, we keep in expert witness.
Mm-hmm.
Well, they're from Jamaica, C. Malone, so that's probably not a bob. It's the beginning of a very large dreadlock.
1 through 10. The 9 that they included were properly included.
Right, I'm moving down from that. So burden of proof instruction, law enforcement instruction, expert witness instruction. We keep in the paragraph in regards to immunity. So now Ms. Dugan, have you caught up?
Yeah.
Okay. Now we will keep in the defendant
Okay.
has become a witness, so we can
Right.
take off the shading off of that. And keep in the next 2 paragraphs and then take out defendant not testifying.
Right. I had left that.
Okay, defendant statements.
Your Honor, we would ask that be removed from the research I've done. That seems to, the language of the instruction talks about whether a statement was made knowingly, voluntarily, and freely made. It seems to deal with statements of the defendants that were made to police, like a confession, anything of that sort, and there's no evidence that Ms. Magbanua has given a formal statement to the police.
Any discussion from the state?
We don't have any objection to taking it out. It's just usually a standard one
That's not
anytime Any?
All right, we'll take out defendant statements then. Rules for deliberation. We keep in all of those except for number 7.
7, yes, that's what I was going to say. I don't
Okay.
believe that was applicable in this case.
Let me know when you're ready. Okay, and then so we'll have renumbered to just 7 of those. Cautionary instruction and single defendant multiple counts.
No objection, Your Honor.
All right, thank you. I'll need a verdict form.
Oh. Right.
So did you send that to me? I didn't get one.
No, so we have some verdict form.
All right, if you could send me one in the morning,
Well, I have to get
then we'll go over that in the morning. And then submitting the case to the jury.
Your Honor, of course, I just have to lay the record. For the verdict instruction, I would, of course, object to the inclusion of any language that deals with lesser included based on my prior objection. But
All
based
right.
on Your Honor's ruling.
All right,
We'd have
and
to keep it in.
you can put that on the record when I show you the verdict form.
Okay.
Also. So submitting the case to the jury, anything in regards to that?
Your Honor, there was one line that was left out from the standard, which is in the second paragraph, which would be the second sentence after "are present in the jury room." The language that was left out was, if a juror goes to the restroom, the deliberation should stop until the juror returns. That's the only discrepancy I saw with this time.
All right, what number is that instruction, do you know?
No, there were no numbers.
Is it, let's see.
It might be 3.13.
Submitting case to the jury instruction?
1-3?
Oh, I guessed well.
Okay,
It's 13.
yeah, so there's one
Second
sentence.
paragraph, the second sentence, it says something about the restrooms. If a juror goes to the restroom, the deliberation should stop until the juror returns.
If a juror goes to the restroom, comma, the deliberation should stop until the juror returns.
That's the only line that I saw that was not present.
All right, we'll include that.
I think that maybe was the last time we did.
It might, no, I think it was updated since. That's why I had to go to the website to make sure, because I know that it's been a couple of years.
Got it?
Yeah.
All right, I think that we're set then.
Your Honor, just one more thing.
Oh,
The
what's
last
that?
paragraph, it says during the trial, items are received into evidence. You may examine what exhibits you think will help in your deliberations. The standard language gives 2 options. Either A, these exhibits will be sent into the jury room with you when you begin to deliberate, or if you wish to see any exhibits, please request that in writing. I didn't see any language that said the exhibits will be delivered to you shortly, so I'm not sure if Your Honor wanted to select A or B. We're fine with whichever one the court would prefer to keep in.
Let's see. The exhibits will be delivered to you. All right, so the exhibits will be sent into the jury room with you when you begin to deliberate is appropriate.
Yes, I left that up to Your Honor's. I didn't know if you'd want them to request it before they see, or if you would just send everything back. And so either one would be fine with the defense.
Well, they have the capability to view video and audio back in the jury room, in this jury room, I believe. I checked on that.
What about this special equipment though? If they want to hear Dolce Vita or the wiretap calls, they might have to come back in here. Maybe none of us could be in here and they could just come. I don't know.
Your Honor, I wouldn't object if you wanted to add an extra, especially for the Dolce Vita video. So you'd say if you wish to see, that particular exhibit, because I really don't know how they would get the special
Okay, this
equipment.
is what we can say. Let's take out the exhibits will be delivered to you shortly. We'll put
Right.
in these exhibits will be sent into the jury room with you when you begin to deliberate, and then we're going to add another sentence.
Right. Here. I don't know, that might have been an updated one, I'm not sure.
And let me know when you're ready with that.
Got it.
Okay, if you wish to use the audio headphones,
Yeah, I know Matthew K. It's like bunny ears TV antenna, isn't it? On the coming out of his the top of his head there, the way it springs around.
Provided in the courtroom, comma, please request that in writing. Any objection from the defense?
No objection, Your Honor.
All right.
When I'm trying to fix the footer,
Yeah.
I'm,
This is the-
she has two case
Yeah,
numbers,
here's-
it's just,
this is case consultation.
yeah, but there's two case numbers.
Oh, the case numbers are 2000.
Are we putting both of them in the footer?
I've been
Right now?
using both of them because
Okay.
for some reason that's what the clerk's office has. So it's 2016 CF 3036 and 2018 CF 497.
Okay.
And Your Honor, I'd just like to say, I had all the intentions of removing the lessors. I'm going to be honest with the court, I didn't really look through.
Of removing what?
The lesser included.
Okay.
Because we had been asking, so I'm going to go and look through them tonight. I'm sure they're standard, but if I do see anything that I would be happy to contact the state and just to let Your Honor know, but I'm sure they're standard
All right.
instructions. I
I
don't
mean,
think
you
those
can
have
have
changed.
discussions and then just let me know in the morning. But but we'll go with this as the final form unless you have any discussion to change that.
Right.
Okay. And then so Ms. Deegan, you have that. If you could, when you get back to your office, ask somebody to print that out, and can you make the copies?
Yes, sir.
All right, we'll make 25.
Kaza T, welcome back, Kaza.
Like it consistent with-
One part.
No, I think that's the design, so let's go back and do it.
Yeah, as soon as we're finished with this case, we're going to do a few non-Adelson criminals, DJ
All
Miller.
right, are we all set?
Dahlia will be one of them.
I'm
Okay.
gonna email these to everybody if that's okay, just in case there's anything else.
Right.
Okay.
All right, they're coming as an email to everyone. All right, we're all set then with the charge conference, and so tomorrow morning we'll meet back here. Starting promptly at 8:45. We'll have the jury instructions ready to go. Read the jury instructions. We'll go right into closing. All right, who's for the state, Ms. Dugan? Who's doing closing for you, Ms. Kappelman?
Yes, sir.
All right, she's not here. Okay, and what about for the defense, Ms. Kawas? All right. So I want to get them into the jury room by lunchtime. So are we gonna, these jury instructions aren't gonna take that long to read. So we're gonna be starting at approximately 9 o'clock. All right, so, do you think 90 minutes is sufficient for you, Ms. Kawas?
Your Honor, I think so. 90 minutes and 90
All right,
minutes.
so I'm gonna hold you to that, okay?
I won't talk too fast, I promise.
All right. And so if Ms. Kappelman can get the same message,
She's quite flamboyant, isn't she? You know, this is a court of law, Tara.
and then as I stated to the jury, then I'll excuse the alternates. We'll send them back to start deliberating at that time, and I'm going to provide them lunch. And then I'm going to tell them, now the time is in your hands in regards to that. Okay?
Just to be clear, Your Honor, the 90 minutes, she can divide up however
She can, yeah,
All right.
however she chooses.
We don't have that option.
Okay? All right, anything else before we break for the evening? From the defense?
Not from the defense.
Good? From the state?
Yes,
No.
sir.
All right, thank you. All right, we're in recess till tomorrow. Thank you.
Okay, let's go to actual jury instructions.
Introduction to final instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Statement of charge. Katherine D. Magbanua, the defendant in this case, has been accused of the crimes of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Introduction to homicide. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Daniel Markel was killed by the defendant, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide.
So, if someone is in my house committing a felony, and what's a really low-level felony? Like, if they are possessing cocaine, an amount of cocaine that indicates intent to distribute, but they're not doing anything to me, I can kill that person legally? Like if someone comes into my house, let's say Robbie. Robbie comes into my house and has a felony quantity of cocaine in his pocket. No gun, no knife. He's just got the felony amount of cocaine in his pocket and he's standing in my house. He's committing a felony while being in my dwelling, right? So if I shoot Robbie in the face, that's a justifiable homicide? Really? I mean, it sounds like that's what he said. Let's hear it one more time.
Or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing.
I mean, it sounds like that what I just said is accurate, right? If someone's got a felony quantity of cocaine in their pocket, no knife, no gun, no threat to my life, but they've got the cocaine, felony quantity, they're committing a felony in a dwelling where I am, I'm allowed to kill them. I mean, that just seems ridiculous.
Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Number one, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or number two, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or three, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. Count 1, first-degree murder. In count 1, Katherine D. Magbanua, the defendant in this case, has been accused of the crime of first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Number 1, Daniel Markel is dead. Number 2, the death was caused by the criminal act of the defendant. Number 3, there was a premeditated killing of Daniel Markel. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. When there are lesser included crimes. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he or she is accused, there may be evidence that he or she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. Second-degree murder. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Daniel Markel is dead. Number two, the death was caused by the criminal act of the defendant. Number three, there was an unlawful killing of Daniel Markel by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and number two, is done from ill will, hatred, spite, or an evil intent, and three, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Number one, Daniel Markel is dead. Number two, the defendant intentionally committed an act or acts that caused the death of Daniel Markel. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death.
Yes, Pariah, soap's fine. We think it's just a muscular thing from her vaccinations, which can happen. Just spazzy cramps, spazzy soap cramps. She's fine. She's asleep.
Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Principles. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he or she had done all the things the other person or persons did if, number one, the defendant had a conscious intent that the criminal act be done, and number two, the defendant did some act or said some word which was intended and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal under either theory, the defendant does not have to be present when the crime is committed. Principals when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all of the things the person who was promised or receive the money did if 1. The defendant had a conscious intent that the criminal act be done, and 2. She made or promised the payment in exchange for the commission or promise to commit the crime or to help commit the crime, and 3. The crime was committed by the other person. To be a principal under either theory, the defendant does not have to be present when the crime is committed. Count 2, conspiracy. In count 2, Katherine Magbanua, the defendant in this case, has been accused of the crime of conspiracy to commit first-degree murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, the intent of the defendant was that the offense of first-degree murder would be committed. Number 2, in order to carry out the intent, the defendant agreed, conspired, combined, or confederated with another person to cause first-degree murder to be committed, either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or words passed between the conspirators. It is not necessary that the defendant...
Hey, that might come in handy at Wendy's trial, right? In order to be, what was it? Charged with conspiracy to commit murder, it is not necessary that any particular words be, I'm paraphrasing, any particular words be exchanged. I mean, yeah, we should hear that again because that sounds very relevant to Wendy.
Or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or words passed between the conspirators. It is not necessary that the defendant do not act in furtherance of the offense conspired. Count 3, solicitation. In count 3, Katherine Magbanua, the defendant in this case, has been accused of the crime of solicitation to commit first-degree murder. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, the defendant solicited Sigfredo Garcia and/or Luis Rivera to commit first-degree murder. Number 2, during the solicitation, the defendant commanded, encouraged, hired, or requested Sigfredo Garcia and/or Luis Rivera to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant did any act in furtherance of the offense solicited. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information and indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond. To overcome the defendant's presumption of innocence, the state has the burden of proving the crimes with which the defendant is charged were committed, and the defendant is the individual who committed the crimes. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider are: number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? Number two, did the witness seem to have an accurate memory? Number three, was the witness honest and straightforward in answering the attorney's questions? Number four, did the witness have some interest in how the case should be decided? Number five, does the witness's testimony agree with the other testimony and other evidence in the case? Number six, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Number seven, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number eight, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Number nine, has the witness been convicted of a felony? Number 10, does the witness have a general reputation for dishonesty? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, has been promised immunity from prosecution, or hopes to gain more favorable treatment in his or her own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Rules for deliberation. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based.
Yeah, I really like this judge too, Pinto. I mean, as much as I love Judge Everett, I think I like this judge even better because he's just, he just takes his role very seriously, and I'm sure Judge Everett does as well. But do you know what I mean? There's a certain pure dedication to his work. Again, I'm sure Judge Everett has that too, but he also has that big smile, which is fantastic.
Based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Single defendant, multiple counts. A separate crime is charged in each count, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, and it reads as follows. Okay, and I have the verdict form up here, and I'm going to read it to you, and of course this will go back to the jury room with you. Verdict. We, the jury, find as follows as to count 1. Check only 1 as to the letters. A. The defendant is guilty of first-degree murder. Or B. The defendant is guilty of the lesser included offense of second-degree murder. Or C. The defendant is guilty of the lesser included offense of manslaughter. Or D. The defendant is not guilty. We, the jury, find as follows as to count 2. Check only 1 as to the letters. A. The defendant is guilty of conspiracy to commit first-degree murder. Or B. The defendant is not guilty. We, the jury, find as follows as to count 3. Check only 1 as to the letters. A. The defendant is guilty of solicitation to commit first-degree murder. Or B. The defendant is not guilty. And it's signed and dated by the foreperson. All right, before I read this final instruction to you, the attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence. However, do listen closely to their arguments. They're intended to aid you in understanding the case. Each side has been given sufficient time, but the state is entitled to a rebuttal argument after the defense has presented its closing argument to you. Okay, so we start with the closing arguments at this time, and the state proceeds first. And Ms. Kappelman, you may proceed.
Okay, finally we get to some meat on the bones. Let's go and grab Kappelman's closing. You know she's going to do a good job. Damn good job. I
Thank you, Your Honor. May it please the court. Counsel.
Counsel. May it please the court. Counsel. She hates them. They really, really hate each other. The two counsels.
Members of the jury, good morning.
What a queen. What a queen.
This is Dan Markel. Dan Markel is the only victim in this case. This is what he looked like before this defendant sent her friends up to see him. And this is what he looked like afterwards. The evidence has shown that on July 18th, 2014, this community suffered a tragic blow when this revered law professor, colleague, son, father, brother, and friend was gunned down in broad daylight in his own home. And what enemies had Dan Markel made that set his brutal fate into motion? His own family. And what offense had Mr. Markel committed against these people? Refusing to let his children be taken away from him? Objecting to them disparaging him to his kids? What was the motive for this heinous murder? The motive is clear. It's undisputed that the divorce between Wendy Adelson and Dan Markel was a particularly nasty one.
Yeah, I'll say.
Fucking A, bro. I'm gonna fucking fuck up where the fuck you fucking with me.
Thank you, Pinto, for the coffees. I love that soundbite. I think it's going to stay with us for a while. That's like our trademark. Thank you, Pinto, for the coffees on buymeacoffee.com. Great way to support the channel, and we appreciate it. What was I going to say? Yeah, of course, at this point, Charlie's been arrested, but only for about a month, right? He's probably still on suicide watch, right? And down in Florida, down in Miami, of course, Donna will be watching Kappelman's closing, where she's referencing the Adelsons. What offense had Professor Markel committed, against these people? Refusing to let his children be taken, his own family, his own twisted family.
Look at State's Exhibit 59. This is their divorce file. Over 700 pages thick. They fought over everything from the education, the religious training of their children, down to a tennis racket. In January of 2013, Wendy Adelson filed a motion to allow her to relocate to South Florida with her two children, ages 2 and 3 at the time. As one basis for this request, Wendy Adelson cites that the wife's parents reside in Coral Springs and the wife's brother resides 20 minutes away. The children are very close to the wife's parents. The husband has also created a hostile work environment for the wife at the FSU School of Law. Wendy Adelson viewed herself as stuck in Tallahassee, a word used to describe her situation by Jeffrey Lacoste on the witness stand the other day, and also mentioned in her pleadings on page 152 of that exhibit. In Markel's answer, he seeks continued equal time sharing in Tallahassee. He seeks sole parental responsibility on issues related to the education, religion, and medical upbringing of these children. Markel's dedication to these kids, especially in these areas, is undisputed. He was devout in his beliefs and felt strongly that his boys should be raised in an environment that observed the Jewish traditions, and he was committed to the Jewish faith, a fact that was exploited by Donna Adelson, who suggested that Wendy could threaten to convert her boys to Catholicism in an effort to try to bully Markel into agreeing to the relocation. She also suggested that she and Harvey Adelson and Charlie Adelson would chip in on $1 million bribe to buy Markel's agreement to this move. What a bargain they ended up getting to solve this problem for only $100,000. Consider the venom in the emails that Donna Adelson wrote to Wendy, referring to Dan Markel as an asshole, a bastard, a religious zealot, and much more. A sentiment that continued to fester and grow within that family when on June 20th, 2013, a judge entered an order denying Wendy Adelson's motion for relocation. This is the summer of 2013, the time frame in which Charlie Adelson began looking into all options to resolve his sister's relocation problem, including hiring a hitman to kill Dan Markel. The divorce was final on July 31st, 2013, but the anger and bitterness continued. Even increasing, litigation continued as both parties filed motions alleging that the other was in violation of the marital settlement agreement. Then, on March 26, 2014, less than 4 months prior to his murder, Dan Markel files his counter motion for enforcement of MSA on parenting issues and motion for contempt and sanctions, again alleging that Wendy Adelson was failing to facilitate.
What is MSA? MSA. Marital settlement arrangement?
Communication between him and the kids, and that Donna Adelson was disparaging him. He alleges on that motion that in 3 separate occasions in November of 2013, the kids informed him that their grandmother, Donna Adelson, was saying things like, "Grandma says you're stupid. She says you're trying to take her sunshines away from her. And Grandma hates you." Dan Markel requests the court to enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children and to impose appropriate limitations to safeguard.
Yeah, but remember, Pinto, it was a 2-hour Dateline special with autopsy photos.
The children from being subjected to disparaging comments about their father. And as we know, this was an issue. I mean, this is a hot button. Grandma can't have access to the kids unsupervised if this thing gets granted. But we know it never got decided. It never got litigated because Dan Markel was murdered before the hearing. So back in the summer of 2013, when Wendy Adelson's motion for relocation was initially denied, Charlie Adelson looked into having Dan Markel killed. But as the defense correctly points out, Charlie Adelson didn't even know Katherine Magbanua back in 2013. And hence, the murder did not happen back in 2013. The murder did not happen until Katherine Magbanua came into the picture. The murder did not happen until Katherine Magbanua made it happen. And what about the timing of when Wendy Adelson stood in the kitchen and told Jeffrey Lacoste, "Can I tell you something in confidence? My brother did seriously look into having Dan Markel killed." That statement was made in 2014, just 5 days before Dan Markel was murdered by a hitman. So the seed for this conspiracy was planted when Charlie Adelson began looking into committing the murder in the summer of 2013, after the judge ruled against Wendy's relocation. And it continued to grow in all efforts to coerce and bully Dan Markel into permitting this relocation failed. Then it further festered with this motion to have no contact with Grandma unsupervised. And as Wendy relayed to Jeffrey Lacoste just 5 days before the murder, she was never going to be able to resolve this problem unless something happened to Danny. But this conspiracy took root when Charlie Adelson met somebody that could get it done. Someone who was in a position of trust in his life, a person that was his girlfriend, this defendant. And Katherine Magbanua had ties to the kind of people who were willing and able to walk up to a complete stranger and point a gun at his head and pull the trigger twice. And guess what wasn't a problem once Dan Markel was gone?
And shoot the Prius. Yeah.
Relocation. A couple days after the murder.
Thank you, Jane Creasman. I got 2 out of 3. Marital separation arrangement.
Wendy Adelson and her boys are living within walking distance from the Adelson residence at the Icon. Their names were changed from Markel to Adelson. And just like that, their father was erased from their lives, 2 and 3 years old. No more fights over kosher diets.
That was a nice click, Georgia. It wasn't even near the microphone.
No more squabbles over marital assets. And no more Dan Markel. And they might have gotten away with it if it wasn't for Mr. Geiger, who bothered to be a good neighbor on July 18th, 2014 and invested.
Someone said this to me the other day, that had it not been for Mr. Geiger, that they would have gotten away with it. And that's not true, because, you know, the cops would have eventually found him, and they would have retraced his steps that day, and they would have looked at the surveillance cameras at Premier Gym, and they would have seen the Prius suspiciously following. I mean, just the way that Prius was moving around the parking lot after the Honda Accord, right? It was such like, it was like the Serengeti, right? Like a stalking lion, you know, or a cheetah. And then they'd have, you know, gone to the bus cameras. They would have noticed the aftermarket wing mirror. They would have noticed the missing towing eye cap, and they would have noticed the Florida Sun Pass affixed to the inside of the windshield, which again would have led to South Florida, and they would have checked the cell phone towers. So that guy that said the whole case they would have gotten away with it had it not been for Mr. Geiger, no, that's not true. And you know, just by chance, also, the guy Stuart, is it Schlazer? I think it's Stuart Schlazer, the guy from the School of Arts and Sciences, SAS. He called the cops. You know, he looked up the name of Dan Markel. He's on the phone with Dan Markel when he was shot. That must be haunting. And you know, he was on the phone listening, and he could hear Markel still this like labored breathing. Phone's just there, and he eventually hung up. And then I think he thought that he'd had a heart attack. Maybe he rang the cops, and the cops said, "We've already got someone on the way. Someone's called it in." So there were 2 like unlikely things. It was almost destiny, fate, club fate.
Investigate a situation that was really none of his business because something just didn't seem right. His description of that Prius was critical to this investigation, that identification of that suspect vehicle, a Prius that would later be detected following Dan Markel earlier that day at the gym. They might have gotten away with it if not for the tireless efforts of law enforcement to cull through the mountains of records and data that were collected in this case, really just looking for needles in a haystack. And they found a few. For example, they found Sigfredo Garcia's phone number amongst the hundreds of numbers present at or near the gym that day. They cross-referenced that number with all the call detail records collected from all the Adelsons, which bore a single hit. Call from Sigfredo Garcia to Harvey Adelson on July 1st, 2014. An ill-fated attempt to confront who Garcia thought was his wife's new boyfriend, but who turned out to be the dad of the boyfriend. He got the wrong Dr. Adelson and left a nasty message on the dad's cell phone, causing much embarrassment to this defendant. That was on July 1st, 2014. Another needle in the haystack example is the tracking of Garcia and Rivera's cell phones to particular toll booths at particular times to locate one particular SunPass attached to one particular Prius, which led to a rental contract bearing information implicating both Luis Rivera and Sigfredo Garcia. A third example is tracking down the rental car contract for the first trip and being able to track this defendant's phone to the rental car place at the same time that that car is being rented out by the airport. We discussed in jury selection that although you will not be asked to decide the guilt of anyone other than this defendant, it's going to be necessary for you to understand the roles of each person that's involved and each player that's involved in this case in order to understand how it is that this defendant fits into this conspiracy. And we get to her through these people in two ways, or by two different paths. Path one, the Prius. The Prius led Garcia and Rivera, and those two led to Magbanua. Notice how we get it right in reference to Garcia. We get it right in reference to Rivera. We get it right in reference to Charlie Adelson. And you've heard quite a lot about the government's theory. They call us the government because nobody likes the government. And per the defense, our theory is completely correct in all regards except for one. We got it all right except for her. Got it wrong on her. Everything is not as it appears when it comes to her. And the defense has characterized this investigation as biased. Luis Rivera and Jessica Rodriguez are liars. The cops and prosecutors are all crooked. But please remember that what the lawyers say is not evidence. You must look to the evidence alone in deciding your verdict. And what the evidence has shown is that we had a law enforcement team that had a lot of work to do with a lot of details and a lot of pieces that we had to sort of try to distill for you into one cognizable presentation. And that's what we've attempted to do. The law enforcement team managed to pull a single Prius out of a haystack of Priuses and tie it to two men, one of whom is the defendant's children's father, and the other of whom took the witness stand and told you that she's the mastermind behind this whole thing. The second path this investigation took was the motive, who wanted to kill Dan Markel. The ex-wife and the in-laws hated his guts and are also connected to this defendant, the woman who knew people who could get a thing like this done. This is the defendant's day in court, and we talked at jury selection about the importance of focusing on her and her role. I know that's been hard to
Thanks so much, Laura, for the super sticker. Thank you.
do because the proceedings sometimes felt like we were talking about other people the whole time. And I encourage you to consider the fact that it's easy to point at an empty chair. It's easy to pile on to bad actors when those folks are not represented in court. And I think one of the lawyers pointed out, oh, their lawyers are out there in the audience watching. And, you know, it suits the defendant's purposes in this trial to pile on to everybody else. Everybody else is guilty. Guilty, guilty, guilty. That one did it. That one did it. But not me. I don't know anything. You better believe that when it is time for one of those other actors to be tried in court, it'll be a dogfight just like it was here, except it'll be, she's guilty. I'm not guilty. I didn't do anything. She acted on her own. All I did was make a joke, and she went and hauled off and hired a hitman. So let's review what we can agree on in this case. We got it right that the motive for killing Dan Markel was for the benefit of Wendy Adelson. We got it right that the in-laws were desperate to move her to South Florida and had the money and the audacity to actually do this kind of thing. We got it right that Charlie paid with his stapled money. And we got it right that Luis Rivera and Sigfredo Garcia were paid to kill Dan Markel. It's natural for you to find yourself wondering, you know, what's going on with all these other people? You know, it's okay, it's natural, it's human for you to have feelings and emotions about the case, the people involved, the lawyers involved. You can think Luis Rivera should not have gotten a deal, or Luis Rivera's deal was too great. You can think other people should be arrested, other people should be prosecuted. That's fine. You just have to separate those emotions out and weigh your verdict base your verdict solely on the evidence in this case against this defendant. As we talked about in jury selection, you're asked to make a wise and legal decision solely about her role in this. Was this crime committed? And was she one of the people that committed this crime? Anyone else is for another day and another jury. But you just can't talk about the case without talking about all of them. It's the Adelsons that had a motive to get this murder done so that Wendy could move. You will not be asked to decide about them, but the evidence is clear that the thing was ultimately done for Wendy. Sigfredo Garcia and Luis Rivera were told that it was for Wendy. They believed they were doing it for Wendy. Possibly because that's true. I mean, ultimately it was for Wendy, but also possibly because the person that hired them, this defendant, was walling Charlie off from them. Walling Sigfredo off from knowing that the money was coming from Charlie, the boyfriend, the dentist. The TV is the first piece of code that we hear in this case. Charlie Adelson got Wendy a TV as a divorce present, as a cheaper alternative to hiring a hitman. Then the same TV is her alibi for the murder, a service appointment that her mother set up for her from South Florida, or at least there's some indication of that. And then on the wire, when Donna Adelson is speaking in code in that first call, weird thing to do after being approached by an alleged gangster, she says this TV is going to cost about $5,000, referring to the $5,000 on the note that the undercover handed her. It's obvious they're referring to their conspiracy and hearkening back to this TV as code for the murder of Dan Markel. The players in this case are very smart. The crime in this case was given a lot of...
Thanks so much, Leslie, for the super chat. Leslie says, wishing Soap get well wishes and new MacBook for Metrix. Yep, I think we're going to make it. Thank you, Leslie.
Thought and preparation. We know that the seed was planted for this thing almost a year or more before it came to fruition. They thought of everything. A clever TV-related alibi for Wendy, a frame job for Lacoste, bullet bourbon, and they insulated themselves by hiring this defendant as a middleman between them, the ones that wanted it done, and the shooters. Everyone on the board in this case had some limits to their knowledge. And that was really smart. That made this case much harder to break. But don't let the way that they thought they would get away with this case be the way they get away with this case. Let's talk about Luis Rivera. The defense seeks to discredit his testimony as an extremely bad dude. He's, got this status as a felon and a gang member, and those are things you should definitely consider when you're weighing the credibility of a witness. But please consider that his resume as a bad guy is precisely why he was selected by the other parties to do this thing. I did not hire him to be a part of this case. I didn't hire him to be a witness and wouldn't have if I had a choice. That was done by this defendant. This defendant and her husband selected Luis Rivera to be a part of this gruesome job. Rivera's not my friend from childhood. He's not the guy that my husband spends all his time with. He's not the person that I hired to do a murder. I did not choose him. But Rivera is here because...
Yes, it's the retrial, Cosmic Kitten. How you doing? Leslie, I saw your message come in. I haven't read it properly yet, but I definitely will tomorrow. It's been a busy day, and I've been dealing with Soap as well. So I saw it come in. I'll get back to you, Leslie.
He was willing to cooperate, willing to cut a sweet deal to tell the truth. He had one job, tell the truth. That's all he has to do. He was chosen not only because he's got the right credentials with his gang status and his felon status, and, he's also trusted. He is a lifelong friend of Sigfredo Garcia, and they didn't think he would roll. They didn't think he would talk. They thought he could be trusted. His gang status comes with a code of silence that made him more attractive as a candidate to do this murder with Sigfredo Garcia. And according to the defense, he got this amazing deal of the century to give testimony that I or someone else spoon-fed to him. First, there is no evidence of this. To the contrary, Rivera denies it. All the law enforcement involved has denied it. And with his limited ability to read, you must ask yourself if you even think it's reasonable that he could study the materials. I mean, y'all have seen what this case is like, and provide some kind of fake regurgitated frame job on Katherine Magbanua. And also have the wherewithal to pepper in details that could later be verified. Second, if it's true that I or the law enforcement on the case are so unethical, so desperate to try this case a couple more times, that we were willing to risk our careers and suborn perjury, why on earth didn't we just spoon feed him all the names on this poster so that we could just, get on with it? The actual only condition of his cooperation deal, the sole thing he had to do was tell the truth, cooperate. Nobody put a name in his mouth. Nobody told him what to say. In jury selection, we talked about all the different types of evidence, and you each agreed to keep an open mind to all kinds of evidence. So how do you judge the credibility of a bad dude like Luis Rivera? This particular bad dude has now given 10 statements in this case over a 6-year period about events that happened 8 years ago. So there's going to be inconsistencies. You have to evaluate the inconsistencies and say, is this an important one or not? Does this create a reasonable doubt or not? And only you can do that. Ask yourself if he was honest and straightforward in answering the attorney's questions. Compare that to Katherine Magbanua's testimony. Ask yourself if he seemed to have an accurate memory about the things he was testifying to, and compare that to Katherine Magbanua's testimony in this case. How could he have known about the shot fired through the passenger floorboard of the Prius? Because he was there and he saw it. The fact is that wasn't in any police report. That wasn't in any 2020. And how could he have known that Dan Markel was scheduled to leave town the next day? The day after the murder, a fact that Wendy Adelson confirmed because the defendant told him. That wasn't in any police report. That wasn't on 2020. They were told they had to get it done for that reason. Y'all got to get it done today because he's going out of town tomorrow. Rivera testified that the defendant hired Sigfredo Garcia to kill Dan Markel and that Sigfredo Garcia hired him to assist in the murder. And defendant was responsible for what? Getting the money and paying them when the job was done. And Jessica Rodriguez further confirmed that defendant was involved in the money drop. She said to Sigfredo Garcia, "Did you give him the package?" According to Jessica Rodriguez, this defendant acknowledged that package. Said to Garcia, "Did you give it to him?" Jessica was nosy and wanted to know what was in there. Defendant says, "I don't know." But the defendant's not interested. Jessica assumed it was drugs. Why wasn't the defendant interested in knowing what was in there? She's so anti-drug, and they're dropping off this suspicious package for Luis Rivera that, she's not interested in knowing what or talking about what's in there. So these are examples of direct evidence, the testimony of Jessica Rodriguez, the testimony of Luis Rivera. But you must also consider Luis Rivera's testimony in light of all the other evidence in the case. The phone evidence is consistent with Rivera's testimony. The phone evidence ties both Garcia and Rivera to the murder trip and further evidences Katherine Magbanua as the middleman between the killers and the Adelsons. All right, so let's go to June of 2014. We've got a rental car that month. There's phone evidence consistent with the defendant taking Sigfredo Garcia to Comfort Rental on June 2nd, 2014 at 8:53. She's there from about 8:53 to 8:58, I think, maybe a little longer, where he rented a silver sedan. That was due back on June 5th, 2014 at 8:50 p.m. because it was rented at approximately 8:50 p.m. Could this be a coincidence? Could she have just been out near the airport visiting a friend while unbeknownst to her, Sigfredo Garcia was renting a car at Comfort Rental Car to take to Tallahassee to do a murder of her boyfriend's brother-in-law? Could be a coincidence. It's possible. But if so, she drove all the way out there only to hang out with Kenya for a few minutes, all the while talking to Charlie Adelson on the phone. In fact, she talks to Charlie Adelson for 25 minutes all the way home from the rental car place. Only an hour after renting the car, Sigfredo Garcia gets a ticket in the vehicle and ends up swapping it out for a different car the next day. Now, why would he swap it out if he got a ticket? After the first trip to Tallahassee, the rental car's last known location before its return was this defendant's home. So that rental car was at her, consistent with being at her residence. And then at 4:30 p.m. the next day, she travels all the way back over to the airport, I guess, to see Kenya again for 20 more minutes, consistent with the rental car return. All right, so that's the June rental car. Let's talk about this first trip. Luis Rivera's phone shows the first trip to Tallahassee on June 4th, 2014. Now remember that the cell phone provider had no location information at all for Sigfredo Garcia for any early June events in 2014. So we can't put him anywhere. We can't say he was there, can't say he wasn't there. But we do know that he rented a car for the trip, received a citation while driving that first car, like we just talked about, and that rental car pinged in Tallahassee at Winthrop Park next to Dan Markel's house, where Rivera says they waited while scoping out Dan Markel. When they returned to Miami, arriving in the early morning hours of June 6, 2014, the GPS data on the vehicle is consistent with traveling back to Miami along the same route in time as Rivera's phone. So we only have one GPS location on the way back, and it's consistent. And as I said before, upon returning to Miami, the rental car goes to the defendant's residence, and then the GPS ping puts the car at her home at 8:48 a.m. that next morning. During the first trip to Tallahassee, the defendant and Sigfredo Garcia have 16 total communications or attempted communications over the course of approximately 48 hours, which is how long approximately that first trip was. The defendant also calls Luis Rivera during that June trip, which is unusual. On June 5th, 2014, she dials Sigfredo Garcia at 10:57 and 10:58 p.m. When she can't reach him, she then dials this number ending in 6615, a number that she had saved in her phone as Tato, and that was at 10:59 p.m. It's unusual because this is the first time in the records that we have where this defendant is attempting to communicate with Rivera at all. It's important because it suggests that she knew Sigfredo and Luis Rivera were together. Sigfredo Garcia then returns her call at 11:01. At that time, the two men are in the rental car, headed back from Tallahassee, where they had been for the purpose of surveilling and possibly murdering Dan Markel, her boyfriend's problem.
Thank you, Ryden. Fucking A, bro. Fucking A, Ryden. Yeah, nice one, Ryden. God, I'm letting Georgia do all the talking. Because she's so good at it. Just want to watch. There's nothing to make fun of. It's all tip-top.
Problem relative. All right, let's talk about the July trip preparation.
Just wait until Kawas gets up here, though. We should have a few things to say then, right?
Charlie and the defendant have dinner together on July 14th. So remember, he's killed on the 18th. A couple days before, on July 14th, 2014, Charlie Adelson and the defendant have dinner. We know from the cell records and iCloud messages that they made these plans to eat near the defendant's residence. And then there are multiple communications between the defendant and Garcia that night between midnight and 2 a.m. The next morning, July 15th, Sigfredo Garcia calls Comfort Rental Car. That's the same rental place from the first trip at 9:09 a.m. and then calls the hybrid save gas rental car place at 4:30 p.m. Sigfredo Garcia and Luis Rivera then communicate several times, and then Luis Rivera and Sigfredo Garcia rent the Prius at 6:15 p.m. Then Sigfredo Garcia leaves Shrimp's house, that's Stephanie Carmona out near the beach, and moves toward defendant's house. So there's several communications over the course of that evening between 6:15 and 9:30 between Sigfredo Garcia and the defendant, but the communications between the two stop at 9:30 p.m., consistent with them being together. We don't usually text and call each other when we're in the same room. And their phones are consistent with being at Katherine Magbanua's that night. The Prius also pings at her residence at 10:25 p.m. on July 15th. All right, so let's go to our July trip. Sigfredo Garcia and Luis Rivera traveled to Tallahassee on July 16th at around 2 p.m., getting in around 1 a.m. on July 17th, 2014. Rivera testified that Garcia was talking to and getting instructions from Katherine Magbanua quite a bit during this trip. She says things like, don't do anything stupid, make sure you do everything right. Although this trip was only about 36 hours from the time they left Miami to the time they returned to Miami, there were 22 phone events between Garcia and the defendant in that time frame. And on July 17th, the defendant also says, you have to get it done tomorrow. You have to get it done because he's going to be leaving town. As we know, Dan Markel was scheduled to fly to New York City on July 19th to visit his girlfriend. It's hard to imagine how Rivera could have been in possession of this piece of information if the info had not flowed, as we see repeatedly in our communication records, from Charlie to Katie to Garcia to Rivera. And Rivera says he posted a picture on Instagram and the defendant called and said, take it down, you idiots. You know, you make a post on social media, there can be data associated with that can tie you to where you are. We don't want anybody to know you're in Tallahassee. He obliged and removed the post, which is why we were not able to retrieve it from Instagram. But if you look at the slides for the July trip communication, there is a call from this defendant to Luis Rivera at 11:40 p.m. Again, this is unusual because this is only the second time of anywhere in the records where we see her attempting to call Luis Rivera, with the first time being the June trip. She doesn't get an answer, and she calls Garcia a few seconds later. When she can't get in touch with Garcia, she calls Rivera again at 11:41. Why was she calling Rivera and then calling Garcia when she couldn't get in touch with them? Because she knew they were together. And she was calling to say, take this stupid thing down. They were doing something stupid, just as she predicted. When she can't get one of them, she starts calling the other one. All right, so Friday, July 18th, 2014, this is the murder day. The Prius arrives at Premier at 9:16 a.m. The last phone communications at all between either one of the men that came to do the killing was at 9:58 a.m. when their phones get turned off and remain off until after the murder. The Prius pulls out of the gym parking lot following Markel toward his residence at 10:38 a.m. The bus video shows the Prius turning onto Benton Road, really close to the Markel residence, at 10:44 a.m., whereby they pulled right up behind Markel in the driveway, executed him in cold blood, hopped back in the car, and they're off again. They're on the bus video, leaving town at 10:55. The 911 call from Mr. Geiger comes in at 11 or 11:01. The first phone call either Sigfredo Garcia or Luis Rivera make after completing this murder for hire is Katherine Magbanua. Sigfredo Garcia calls the defendant and says it's done. Defendant says, I know. We don't know how she knew. Maybe they had their phones off and then all of a sudden they called, and when she saw it ring, she knew, oh, it's got to be them telling me it's done. Maybe somebody gave her information before they called that it was done. We do not have that piece of information in the evidence. The defendant assures the killers that they will get their money. They are going to get their money the next day. When we look at the phone activity from all the parties from midnight before the murder through the first call after the murder, and you can see the murder designated by a red line in this slide, we see a flurry of calls between our people of interest. And it's in that pattern, Donna to Charlie to Katie to Garcia and back the same way. Then we see the killers on an ATM camera in Pembroke Pines, Florida. The ATM photos show both Garcia and Rivera in the Prius taking some money out of the bank at 6:46 p.m. The location after this ATM image is consistent with both men being at the Rivera residence at about 7 p.m. So where is Katherine Magbanua once Garcia and Rivera arrived back in Miami after the murder? Friday evening, she's speaking to Charlie Adelson. She's speaking to Sigfredo Garcia. She's also speaking to Yendra. After 8:46 p.m., she leaves her home and travels towards Rivera's residence, getting there at about 9:46 p.m. And on the way there, she drops her kids off at Yendra Mascaro's residence. This was unusual. She didn't usually leave her kids anywhere or anywhere overnight. And it was documented, the date of this particular event, on Ms. Mascaro's social media. Remember, she had to go refresh her memory as to when that photo was taken.
A raspberry beret. That's fantastic. She would look. I think I've seen Georgia Kappelman wearing a beret, but it might have been in a dream.
Of the kids at her house, and came back to tell you that the night that those kids stayed at her house was July 18th, 2014. The night after Dan Markel was killed. The night she needed to go to Charlie's to get the money to pay them the next morning. There's a text earlier in the day where she's making plans to stay at Charlie's house that night. She turns her phone off on the way, and it stays off for almost 11 hours. 11 hours of time when her kids are in the care of Yendra. While she's with Charlie, this is about 14 hours later after the shooting, and this is about the time that Dan Markel is pronounced deceased at the hospital here in Tallahassee, succumbing to the terrible injuries that he sustained when he was shot. When the defendant's phone pops back up after spending the night at Charlie's, the night of the murder, it's Saturday morning, and she's headed back south from Charlie's house toward the money drop location. All right, so let's talk about this. July 19th, the money drop. We've got a 45-minute call flurry that's observed. And again, it's that same sort of pattern of communication that we're seeing over and over again. The defendant's phone is powered on, and she starts calling Garcia at 9:44 a.m. She calls him 5 times and texts him as she's driving south from Charlie's home. When she can't reach Garcia, she calls a number that she had programmed into her phone as Jessica Flocka. That was at 9:47 a.m. Then that number, that Jessica Flocka number, starts trying to reach Rivera as well. And simultaneously, Rivera starts trying to reach Garcia, and the defendant continues to try to reach out to Garcia as well. Remember, he's out at Shrimp's house.
Well, I don't know about a beret, but hang on, guys. Oops. Where's Coach? Where's Coach? So that must be her daughter. And are those Are those the daughter's kids or just younger brothers?
Fucking A, bro. I'm gonna fucking fuck up whoever the fuck you fucking with me.
Oh, Mary Bartlett Borough copy. Thank you, Mary. Yeah, this is that Patricia, this is George's Christmas, special Christmas, Justice Christmas. Oh, whoops. No, I can't log in. The fuck? Let's try another link. Hang on, guys. Hmm. But it's gone. It's gone. I was looking for the beret. Never mind. Never mind. We'll come back to it.
Then Rivera calls the defendant. So that's the call where everyone's like, oh, he called her. She didn't call him. But a lot of things happened before he called her. So he did talk to her. That seems to be undisputed. And defendant now has a working number for Rivera because she's actually talked to him on this new phone, this phone number that he had that he brought to Tallahassee. She then calls him back twice after their last call, and his phone, remember, goes out to Shrimps and then comes back where they're all consistent with being at Rivera and Jessica's residence, and that's when the money drop occurs. Phones put them all there for the money drop. That wasn't in any police report. That's something we got from Luis Rivera and were able to verify with evidence. We learned about the money drop from Rivera and then called Jessica and said, hey, did this happen? And she said, oh, yeah, that did happen. Sergeant Corbett testified about Luis Rivera's locations the morning of the money drop when the call flurry began. So Rivera's phone starts out. There seems to be some dispute about this. It's consistent with his residence or the barbershop, which are close together, when this call flurry begins. Then it travels out to Shrimp's house, where Garcia was, and then they all converge back together at Rivera's place at 10:34 a.m. Okay, so the defendant does not have any activity on her phone during this money drop time, 10:31 to 11:23 a.m. that morning, consistent with her going inside Rivera's for a few minutes, seeing the baby, the package getting delivered, and then going on their way. 11:23 is her next communication, and by then she's just south of Rivera's, consistent with heading to Yendra Mascaro's residence, and we know why she's there. She's got to pick up her kids where she had dropped them off the night before. And when she picks the kids up, what does she say to Yendra? Charlie Adelson's brother-in-law was in a car accident. All right, so let's talk about the financial evidence. Katherine Magbanua began getting checks from the Adelson Institute 2 months after Markel's murder. Is it reasonable that Charlie Adelson would put her on the payroll 2 months after this murder if they were in a status where they had broken up and was ghosting her if she had nothing to do with the killing? She received over $17,000 from the Adelson Institute over the course of...
Listen, this isn't working for me. We're breaking up, but why don't we put you on the books at my dental office and pay you consistently until we've paid you over $17,000. How about that? And anytime during those months, if you need a cruise or a trip to Key West or tickets to the Dominican Republic, call me. Nice guy.
We're doing something that is yet to be determined. Despite my co-counsel's best efforts, she didn't work in the office. She doesn't seem to have been making phone calls on the Adelson Institute's behalf or Charlie Adelson's behalf. Never went to the office on weekends. Didn't clean up. We've established that the cleaner-uppers was a husband and wife team. As far as we can tell, she made an appointment to get a website a month before her first paycheck was received. Many of her checks that she received from the Adelson.
Guys, we've received confirmation that Coach is still with us as of Christmas 2024. Thank you, Teresa, for sharing that with us.
Institute were sequential, meaning written in numerical order, so a bunch of checks at once. She got 6 sequential checks 2 times in just a few months. Other Adelson employees said that they had gotten a couple, I think they said either 2 or 3 sequential checks before, but never 6. And that was only if the Adelsons were going to be going on vacation and miss the pay period. It should be noted that Adelson Institute is, they stopped issuing her checks after Garcia was arrested. You heard about the breast augmentation. So a month after the defendant was added to the Adelson Institute payroll for the supposed purpose of getting Medicaid insurance for her kids, she paid $4,400 in cash for a breast augmentation surgery. This expenditure was just 3 months after the murder. There is no corresponding cash withdrawal from her account for the purchase. And note that June said Charlie had admitted to paying for one of them. Yinder I guess she said that the defendant told her that Garcia had paid for them, and the defendant told you on the stand that she paid for them and had saved up for them. Defendant's highest source of income in 2014 and 2015.
Yeah, that's of 2024 Christmas time. Coach, front and center, where he belongs. So those little kids must have been. Is Georgia a grandmother? Really? I don't know. She doesn't seem like a grandmother.
Is cash. Cash was only 23% of her total income in 2013, but jumped up to 64% of her total income as shown here in 2014.
Oh, was that you, Tay? Oh, okay, because we've got another Teresa in the house that uses the full name. But okay, thank you, Tay.
In 2015, cash checks from the Adelson Institute made up 71% of her total income that year. In 2014, she deposits $46,000, 3 times as much money as the year before the murder and twice as much as the year after the murder. She deposits $13,200 in cash in the month following the murder. That's her big spike. That's more than she deposited in the entire previous year. Whatever she was doing or not doing at the clubs, she is very unlucky if she's not guilty because she happened to have the most incredible month of her life financially immediately following the murder of Dan Markel. All right, I want to talk about the wiretap. When the undercover hands Donna Adelson an article about her murdered son-in-law and insinuates that she was involved and then tries to extort $5,000 out of her, does she go straight to the police? Does she give law enforcement this valuable information that could be used to solve the murder of her former son-in-law? I mean, this guy that approached her supposedly was involved in the murder. So first of all, he's a gangster. He's dangerous. He's murdered one of her family members or knows someone who has or has information about this murder that's unsolved in her family. And she does not call the police. She calls Charlie Adelson. She puts that paper without even looking at it into her purse. Goes, gets the kids, goes back into the Icon, calls Charlie Adelson and says, this TV is going to be about 5. Has to do with the 2 of us. They mentioned an ex-girlfriend. Does Charlie Adelson say, an ex-girlfriend? Whose ex-girlfriend? My ex-girlfriend? Which ex-girlfriend?
An ex-girlfriend? Whose ex-girlfriend? My ex-girlfriend? Which ex-girlfriend? That's like exactly how Charlie would say it as well, isn't he? With all these guesses. You know, like, is everyone's health okay? Is it because I didn't pay the sun pass? It's not the IRS, is it? Is it a bad Yelp review? Anything to do with Wendy?
He doesn't have to ask that. Like, Undercover does put Katie's name in this. He does say Katie. But Donna doesn't say Katie. And he doesn't have to ask which ex-girlfriend. They don't even say your son. They mention an ex-girlfriend. And he goes straight to her. Once Charlie Adelson, meets with his mother and gets the details and the paper with the Undercover's phone number, he goes straight to Katherine Magbanua. They do this meeting at Dolce Vita. And the defendant in Dolce, she took the stand and she claims she does not know there was a murder. She never even knew there was a murder in this case. Not just she didn't have anything to do with it. So y'all have to listen to those wiretaps and consider that as her defense. She's supposedly doing and saying all these things with no information whatsoever that there was even a murder. And this is a college-educated woman. Charlie Adelson says this is either someone trying to blackmail his family or it's the cops working undercover. I mean, that much you can definitely, I can hear it. I hope y'all can hear it. I don't know why she can't hear it. Why doesn't she say, why are the cops approaching your mother? Is there a reason? I mean, what's this about? Did your mother do something that the police would be investigating? Does he even have to explain to her, like, my brother-in-law was killed in Tallahassee, there's suspicion on us, and I suspect this could be law enforcement undercover operation trying to investigate the murder. It could be somebody that has information about the murder that's affiliated with these killers. He doesn't have to explain any of that to her. And they say, oh, well, maybe he did it in the car before they went in there, but she says she never knew about a murder at all until Garcia's arrest in May. Charlie Adelson says if they had any evidence, we'd already be at the airport by now. Even if they bug your phone, you're still not talking about any of this. What else would she have not been talking about other than the murder of Dan Markel? And how could she be talking about it or not talking about it if she didn't know a darn thing about it? Charlie begins explaining how you have to be able to put the person at the scene at the time in order to be able to prove the crime. You can't just say my brother shot JFK. You have to have evidence. So he's reassuring her, we're good. We're not in this. Even if you sat in the Prius, it doesn't matter. A car, just because a car went to do a crime and you sat in it previously is not going to make a difference. They're not going to be able to prove you did the crime. You're not going to be able to prove you robbed the Burger King. Charlie says it's one of two scenarios. So number one being the cops, number two being a legitimate blackmail effort, and at some point a third possibility is discussed, which is maybe this is just somebody who read something in the papers and saw an opportunity to try to go, up to my mother and see if they could make some money. And that is why it was important to give details and information in the bump, because otherwise they would have discounted it as not being legitimate. So what really does worry them and think that this might be coming from the inside is the fact that this person has information.
It is pretty well thought out, isn't it? I've forgotten about that. Like, the reason that they gave Katie's name was if they didn't, then it really would have looked like just some journalist trying to get a scoop. Yeah.
And they talk about that. Charlie says, whoever it is knows information. This person knows information, so Katie, they'll be back. And she says, there's not a lot of people that know much about. Can't hear what she says. What is she? What could she be referring to? Not a lot of people that know much about what? And we asked her on cross. What were we saying there? Not a lot of people that know much about what? She doesn't know. She can't tell you. No memory of it. No information about what happened in that restaurant. No memory of a man coming to you and trying to get you to have contact with some thugs that approached his mother to blackmail her about a murder. Charlie says if they're a bad guy, there's two ways of dealing with it. Go ahead and contact the police. They'll contact him and arrange a setup, take him down, and he'll proffer 10 years and tell everything. Tell us everything you know, or else you're going to serve 10 years in prison. The next thing you know, this person is singing. He starts calling your name out. And my parents are going to have to tell the story of what happened. Why would a bad guy be calling her name out if she knows nothing? Why are the cops knocking at her door an issue of concern for her if she knows nothing? They talk about going to the cops, going to the FBI, but nobody ever does that obvious thing, including this defendant. If you're innocent and a bad guy is out there trying to put your name in something, you go straight to the cops. All right, so Charlie says, this is my idea. I give you the money. You talk to him on the phone, and he gives very precise instructions. Say, my friends have no idea what you're talking about, and frankly, I don't know what you're talking about, but the name sounds familiar of who's incarcerated, so I'm going to give you something as charity to help the less fortunate. But do not contact these people again, or they're going to the police. He's instructing her to call this thug and say something particular, okay? And the whole time, just say, I don't know what's going on, and only use the words help and charity. Then he talks or mentions who we think and are arguing is Sigfredo Garcia. He says, now he's fucking with his wife, and he's fucking with him, and you fuck with the king himself, you'd better kill him because he's going to be a big problem. Katherine Magbanua, seated at this table in Dolce Vita, having no information whatsoever about this case, no knowledge whatsoever about a murder, it's been suggested to her that she might need to kill or arrange to kill or have Sigfredo Garcia kill this undercover operative, who they think is a thug. And what is her reaction to that? My God, she continues to engage in the conversation. She gets up and goes to the bathroom and comes back and then goes out to the car and goes about her business, and then she engages in following up on the instructions he gave her. And she doesn't call the number. She tries to get Garcia to call it. She doesn't say kill. I'm not killing anybody. What are you talking about? Kill. Kill might be a word you might remember. Okay, Katherine Magbanua. What did you think when he said you might have to kill the guy? I don't know. I have no recollection of that, no knowledge of that, no information whatsoever to give you. All right, well, after he said he was going to kill the guy, why'd you go out and do what he asked you to do? Why didn't you just say, oh, okay, I'll take care of that? Police. Because she's involved. I mean, there's no other explanation. I'm not taking it out of context. There is only one context. The alternate context is, I don't know anything. Can't offer any context. Can't tell you what I was thinking. Can't tell you why I did what I did. Because I have no memory of doing it, no memory of saying it, no memory of being there. Can't offer you nothing. Then Charlie says, and so help me God, and please, I know I'm dropping all these F-bombs on you, but it's not my words. And so help me God, if they fuck with my family, it's gonna be fucking Nazi shit, because this will be done. I mean, Katie, I don't care what I spend, okay?
Ooh, just caught the mute button there. There's something a bit surreal, isn't there, about watching a nice woman standing in a stunning suit at a podium in a courthouse saying, and so help me God, if they fuck with my family, it's gonna be fucking Nazi shit. It's just, remember Charlie from his testimony? No, I laughed when you said the word fucker in court. Yeah, well, what about this? Man, I tell you what, though, we're going to be doing soon is the trial of Michael Dunn. Well, we'll get there, but his defense attorney goes for a real shocker, a real shock value uh, attention grabber of a shouting uh, uh, obscenities in court. It's almost, well, it is pretty much over the top. And one of the things he shouts is, fuck that N word. But he says the word to a room full of black people. It's really like, whoa, it does really grab your attention. Where's play button?
He doesn't care what it costs him. She needs to take care of this problem.
Yeah, everybody join us on Discord. We've got links in the description to all the social networks, including Discord, which is the best. Then we've got Instagram, Twitter, Facebook. We've got ways to support the channel at buymeacoffee.com/truecrimemetrics. We've got merchandise in the merch store at merch.truecrimemetrics.com. Links in the description. YouTube memberships and Patreon memberships. And you know what else we've got? Lifetime coffee memberships, guys. Check it out on buymeacoffee.com/truecrimemetrics.
Then they talk about Garcia. He doesn't have any bad feelings toward me, does he? Our paths never crossed. He's making sure everything is kosher with Garcia to get this thing resolved. There's more evidence here that Charlie doesn't have an independent relationship with Garcia because he's going through her. Is he going to, if someone's on to him and it's somebody that this information is leaked to, or it's worse, law enforcement, he is not going to invite someone new into his conspiracy. He's checking with her to see if Garcia has any bad feelings toward him. After he talks about having someone killed and not caring what he has to spend, he checks in on Garcia and then assures her that she will be taken care of. Quote, I don't have to sit here and tell you what I would do. I show you what I could do. You know what I'm saying? You know how I am. I look for things to do. You don't ask me for shit. I'm the one that's like, hey, someone's birthday's coming up. I got you. I'm the one who's like, I'll sell you the Lexus for a very good price. I know you're having car problems. And then he says, listen, you giving somebody money is not an admission of any kind of guilt. Guilt of what, folks? What would she be guilty of? She doesn't even know there's a murder. Charlie, let me ask you a question. When everybody was there the next day, and there's something about money, and then he says this, it's not like you're driving around in a Bentley, cruising around in a mega yacht. At the end of the conversation, he says, you know who this is coming from. The inside. Katherine Magbanua, what did you understand that to mean? It's coming from the inside. She doesn't know. I don't know. And wasn't curious to find out. And wasn't curious to call the cops. To end it. To get herself out of it. In these initial recordings that we've got, the Dolce and the first few calls, it's like they're dancing around each other, you know, the code and I don't know, it's like neither one is sure if the other is working with law enforcement. Neither one is sure if the other is affiliated with the blackmail attempt. I mean, she's sure he's not. He's not sure she's not affiliated with the guy that approached his mother. He's not sure she's not wearing a wire. And she can't be sure that this guy that approached Donna Adelson isn't in fact one of Rivera's brothers. And you'll hear her on the wire clarifying that a couple times. Did he say brother or did he say family member? Because brother potentially could mean gang member, right? And she isn't honest with Charlie about those concerns because she's walled him off from Tudo and Tato. And neither defendant nor Charlie can be sure, you know, what this thing really is, what the risks are here. So they're both just sort of feeling each other out. After the meeting with Donna that we saw, Charlie and Donna there at the marina, there's several calls where he's assuring her, like, this is being handled. Don't worry about it. You know, Mom, you're freaking out. It's nothing. I got this. It's all handled. We hear call H. H is the first call where we hear Garcia, and he is not happy. He doesn't sound like a guy who's done something stupid and gotten her involved in a murder that he's to blame for. It sounds more like he's someone who she's gotten involved in something, and now he's going to have to clean up the mess. Maybe because, you know, she came clean about, I don't know, he's angry. He's angry. Ultimately, Garcia says he will take care of the problem. The less she knows, the better.
She's doing an impression of him. I'm going to take care of this fucking problem. I love it when Sigfredo says, right now I have a more pressing matter that I need to attend to. What the fuck? What the hell is going on with that sentence, Sigfredo? That just doesn't seem like you. Are you doing your impression of a businessman or what? Right now, I have a more pressing matter that I need to attend to. Oh, I'm gonna take care of this fucking problem.
Stop talking about it on the phone, and he hangs up. All right, so then the defendant calls Garcia with a number. She repeatedly is talking in code about a phone number. Why on earth would she be talking in code about a phone number? Just say 6570. The number is 6570. But instead she says the kids' clothes cost $65.70.
What the hell is that as well? Yeah, I'm shopping for the kids' clothes and it comes to $65.70. Or maybe it was $67.58. She can't even remember the number. Yeah, so could you transfer the $65.70?
He doesn't get it. It goes back and forth several times, and finally he does get what she's saying. The defendant's asked about talking in code and why it was.
Yeah, and then when he gets it, he says, "Got it." Oh, yeah. It's like a Navy SEAL quality, that, isn't it? Training in the field. Got it. She's like, the number I wrote on the paper, $65.70.
Necessary if she had nothing to conceal. And she says a couple things. One, she says she had to disguise the phone number while speaking on the phone because her coworkers were around, which makes no sense. Two, she says, oh, I just started talking in code because I picked it up from Charlie. Doesn't make sense that she would then carry it over to her conversations with other people, including Sigfredo Garcia. The only reason to talk in code is for fear that the call might be being recorded. This is the time frame. You hear that bad argument between the defendant and Sigfredo Garcia. They split at some point in call M. She's wanting to talk to him and he's not interested. She sends a text saying she needs to talk to him about something. That's text N. And also in text O, he replies and says, whatever is going on with you and your homie is your business. You guys work that shit out. Don't text me. Call P, where the code really good client is born. Defendant says she has forgotten the number for that client. And Charlie says he'll get it to her. Then he calls his mom and says, hey, what's the number on the paper? She says, I don't know, I gave it to you. So then he's got to go home and get it. There's a volley of calls, a lot of number confusion where everybody's talking about the number. But when I say everybody, what I mean is Donna to Charlie to Katie to Garcia and back that same way. Never jumping over one car. So if you think about them like train cars on a track, got to go through one to get to the other. In call R, Charlie tells the defendant that it's going to be a while before he can get the number. Again, she initiates code saying it's always so hard to get that particular agent. Then we get call S, where Magbanua is giving Garcia the undercover's number again, and she does it in code. Remember one of the listings I had to tell you, one of the properties. I believe it's 305 712 6570. Then call U is from Donna to Charlie about the undercover calling the office. So that's the tickling the wire. And we went through that during the testimony. And that's when we get to call W. And this is the call W where I say we've got an illustration of the fact that there's two Katies in this case. We've got Katie that was on the stand, and we've got the Katie that was in call W. When Charlie calls and informs her about the call to the office, he's getting a little fussy with her, pressuring her, find out what this is. And she pushes back. It's really important because when she pushes back, she kind of drops the code and comes really close to revealing the truth more so than any other statement she's made. Charlie's trying to get defendant to call the number. The defendant is trying to get Garcia to call the number. Garcia is lying to the defendant, saying he called the number when he didn't. She's lying to Charlie, saying she called the number when she didn't. And Charlie's lying to his mother, telling her everything's fine, handled. Eventually, Charlie ends up calling the undercover, and y'all heard that call. So what does he say when the undercover says, you know, your family's problem up north has been taken care of. You've been taking care of Katie and Tudo, but haven't done anything for Tato. What does he say about this family problem up north? Does he say, I have no idea what you're talking about. Why did you give my mom a picture of my murdered brother-in-law? What do you know about that? What information do you have? Who are you? You know, he just says, all right, let me look into things. Then in call Y, Charlie Adelson is reporting back to Katherine Magbanua what the undercover told him in that call.
Thank you, Instant Nerf, for the super sticker. Well done, Instant Nerf.
And Charlie says, the undercover says Tudo and Tato, although he struggles with those names because he doesn't seem to know them. Magbanua doesn't enlighten him as to who those people are. I mean, she knows who Tudo and Tato are. She's supposedly trying to help him. She doesn't know anything about this murder. She's only trying to help him.
These people don't know what you're talking about. And frankly, I don't know what you're talking about. But the name sounds familiar. So I'm going to give you something as charity to help the less fortunate. But don't go to these people again or they're going to the police. I love that.
Because his family's being harassed. Yet, in her help, she doesn't suggest, well, Tudo and Tato are these two guys. That's because she's insulating Garcia and Charlie from each other. She's walling them off. She was the glue in this conspiracy. It does not work without her. Call Z, Katherine Magbanua reporting the latest bump to Garcia. And she says, quote, this is call Z, it's getting too detailed. It's somebody that knows for sure. This call ends with more discussion about what the number is. Garcia.
Yeah, you know who knows? The fucking FBI. Because they've been trying to get you for 2 years. They're real well versed in this now.
Garcia wants her to text it to him, and she says, no, I don't want to. Why? Why don't you want to text it to him? Why are we talking in code? You're just trying to help out a friend. Figure this thing out. You have nothing to do with it. Call DD. Charlie is further relating his discussion with the undercover. He said he was brothers with someone in Broward. And she clarifies again, and that's the call where she's saying brother or family member a couple times. And that's the call where she says, they really mess with the wrong person. I fuck bitches up for no reason. You know, she's talking really tough. Call FF. Katie is bragging about the really nasty voicemail that she left on the undercover's voicemail, when the truth is nobody had called and left any such voicemail on the undercover's recorder. So she's playing both of these guys. She's lying. She's manipulating both sides of this conspiracy. And then we've got call GG, which you got a couple more calls after this on the exhibit, but this was the last one that I played because I felt you guys were starting to yawn. But understandably. But she says in that call, it can only be one of two, apparently. And they're talking about different scenarios. If somebody's that desperate, not from the inside, I mean, I'm not saying this makes sense, but not from the inside, because there's too much from the inside that the other person knows from the outside, so they won't risk it. That's why I know for a fact it's not from the inside. It's somebody trying to be greedy. Probably, you know, hey, everybody knew who I've dated in the past and stuff. I've had a couple boyfriends, you know. So she's saying, like, I have investigated the matter, and I do not think this is a legitimate threat from the inside of our conspiracy to murder Dan Markel. Charlie replies, it's somebody not from the first layer, but probably the second layer. Yeah, and they just made a big mistake. So that's sort of the finale of the evidence in the case, is her saying she's resolved it. So it's not somebody from the inside. I want to turn my attention a little bit to the jury instructions. The defendant in this case is charged with conspiracy to commit murder, solicitation to commit murder, and first-degree murder as a principal. Why all three charges? The defendant didn't just ask Sigfredo Garcia to do this and pay for it. That would be solicitation. She didn't just take Charlie Adelson's family problem and turn it into action. That would be conspiracy. She got the thing done. Dan Markel is dead. This is the work of this conspiracy, and this is why there is a murder charge, not just conspiracy and solicitation. To prove the crime of first-degree murder, I must prove to you that this was premeditated. I don't even want to talk to you about the lesser included offenses because there's so much evidence of premeditation. Like, whoever did it was definitely premeditated, right? Premeditation is defined as killing after consciously deciding to do so. So I think that's abundantly clear. This murder was in the works for over a year. It began with the failed relocation efforts when Charlie first looked into hiring a hitman, and it took root when Katherine Magbanua enlisted Garcia, who then enlisted Rivera, to do this killing. The planning that went into the killing was extensive, spanning a 6-week period, including 2,000-mile trips to Tallahassee, made in rented vehicles, scouting and stalking Professor Markel. All the planning, all the meetings, and all the calls came to fruition when Sigfredo Garcia fired those 2 shots into Mr. Markel's vehicle, which devastated so many lives. When you think about how this case was proven, we started at a single point, the crime scene. And we went in 2 totally different directions. We chased a Prius, and we chased the bad blood with the in-laws. All these little breadcrumbs led to the same place. The Prius led to Garcia and Rivera. The bad blood led to the Adelsons, and both trails lead to this defendant. I want to spend a little time talking about the principal instruction, and we talked about this in jury selection. Katherine Magbanua didn't pull the trigger that day. She didn't come to Tallahassee, but that doesn't mean that she isn't just as responsible as the folks that did. And the people that hired her to do it. Think of it like this. If you have a gun, each player can be a part in how the shot is fired. Garcia was the bullet. Charlie Adelson was the finger wrapped around the trigger. The defendant was the gun. Without every piece, without every function, without every part of it, you don't have the end result. And Dan Markel would still be alive, may still be alive. So in your jury instructions, it says there's 2 ways to prove Katherine Magbanua's guilt under the law of principles. 1, if she intended that the murder be done and she did some act or said some word that caused or helped another to commit the crime, then she's guilty of first-degree murder. Or 2, if she intended the murder be done and she promised payment in exchange for the murder and the crime was committed by another person, then she's guilty of first-degree murder. So there's 2 ways. It can be either or both. In this case, I would suggest it's both, but if y'all are unanimous on either, then your verdict should be guilty. Luis Rivera called the defendant the mastermind. He said she hired Sigfredo Garcia to do this murder. She told him when the murder needed to happen because Markel was leaving town the next day. She gave Garcia spending money for both trips to Tallahassee. She drove Garcia to get a rental car. She got angry with Rivera when he posted something on social media from Tallahassee. She got the money from Charlie. She delivered the stapled money to the killers. And finally, she got paid too. The burden today on the state is to prove to you this case beyond a reasonable doubt. The jury instructions tell you that a reasonable doubt is not a mere possible, speculative, or imaginary doubt. It's not forced. So when you're back there deliberating, ask yourself, you're going to have to assess these things. Is this a reasonable doubt? Is this a reasonable doubt? What is reasonable? If you find yourself speculating, then it's not a reasonable doubt. Well, what if it's possible that? If you don't have evidence to support it, actual evidence, not what the lawyers say, evidence, testimony, or items introduced, then that's speculation. I want to touch on the defendant's statements just a little bit more. She took the stand, and there's some things that we heard from her. She was confronted with the fact that Charlie did a lot of favors for her right after the murder. Even though they weren't together, he paid for a trip to the Dominican Republic, offered to pay for a cruise, paid for car repairs, gave her money and loans when she asked for it. You saw a text where she was asking for money and then the next day deposits $1,400 worth of cash into her account. And he put her on the payroll. The defendant told us when her attorney was asking her questions that the defendant had ghosted her prior to putting her on the payroll. If he ghosted her after the murder in August of 2014, why would he want her to become his personal assistant? She could not answer that question. When asked, what do you do as his personal assistant? She could not answer that question. These are easy questions, folks. What was your job? She couldn't answer them. She said she didn't schedule patients. She said she set up an appointment. You know, you heard about the one appointment. She said she collected rent but couldn't tell you when or from whom. She was paid over $17,000 over the course of a year and a half to help Charlie set up an appointment to go get a website, and that was done 2 months before she started collecting the money. Why would Donna Adelson agree to write all these checks to her son's ex-girlfriend who wasn't doing anything for the money? What about that text about what she had done for the family? What about her? It's so special. And he's got a million ex-girlfriends. He's not paying for all the stuff for them. She couldn't answer that question. You heard she was previously questioned in 2019. You heard about this jail interview where the defense invited my team to come ask her anything we wanted. And you saw Ms. Dugan do her damnedest to ask questions. And it's like trying to nail Jell-O to a wall. You're not going to get answers. Where were you working in the summer of 2014? Don't know. You heard from Yindra about the work. You heard from the club owners that she wasn't making the kind of money that she says she was making there. She said she was making $1,500 a night, but the evidence is to the contrary. And if she was doing it, she only did it the month after the murder. The wiretap calls. Defendant says Charlie called her because she was his last ex-girlfriend, but we know that's not true. When Charlie was acting like he didn't know who Tudo was on the wiretap, she doesn't enlighten him. He doesn't know who Tato is. She doesn't enlighten him. The only reason they're walling each other off, the only reason they're speaking in code is because they are guilty, because they are concerned law enforcement is listening. She testified that she knows nothing about this crime at all, even after the bump and all of her involvement in these wire calls and calling the number, not calling the number, getting someone else to call the number. She says she did not even know there was a murder. In opening statement, the defense told us that they would offer definitive proof. Can we have the next slide, please? That there was a link between Garcia and Katherine Magbanua that did not involve this defendant. And now you have seen all of the evidence in this case and heard the testimony of the witnesses, including this defendant. And we are no closer to proving the defense's theory than we were in opening statement. What is the smoking gun? The fact that they both had the same auto mechanic? That would be speculation. A reasonable doubt is not a speculative doubt. Has the evidence shown communication through the auto mechanic? No. To the contrary, the evidence has repeatedly shown communication through this defendant, communication around all the critical times in this case, communication that was overheard by or relayed to Luis Rivera, communication related to the murder even on the wiretaps. You get to hear them talking about issues related to this case, and you get to see how the communication does in fact flow through her. You don't have to guess. You don't have to just look at the communication pattern and listen to the testimony of Luis Rivera. You can hear it for yourself. What happens when we plant information in the hands of Donna Adelson? It goes boom, 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 right down the line. She is right in the middle of it, as she acknowledged. I know how it looks. I know I'm right in the middle of it. But she's not there because she was manipulated by others. She's there because of the choices that she made. I've been straining my pea brain trying to figure out why the defense, who agrees wholeheartedly that Sigfredo Garcia did this murder, has worked so hard to suggest that he wasn't on that June trip with Luis Rivera. And you remember the traffic ticket where there's that little box that you check for if it's a 16 passenger vehicle or not, and it wasn't checked, and they're interpreting that to mean Rivera was the only one in the car. It finally came to me this morning that it's because their confrontation at dinner theory, so there's no evidence of a confrontation at all, but there was a dinner that occurred in March of 2014. Lacoste was there, Wendy was there, Charlie was there, and this defendant were there. Luis Rivera told you that Garcia was furious. He couldn't stand Charlie's guts, and he and Rivera...
He and Rivera what? Let's have a quick look at this, guys. Let's play a game. Oh. Hmm. Um, hang on, I need to just make that an image. Da 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 da. Mm-hmm. What else can we do? Describe what you want the AI to generate. Um, well, I don't know. This. Can we specify what would Georgia have as an accessory? A banana. And a briefcase. Banana briefcase. And well, let's just try it with that. Toy action figure. See, we could generate Georgia as a Simpsons character. Whoa, I almost fell asleep then. My head dropped. I didn't really sleep last night either. Crazy. Sunday, I haven't really slept since Thursday. Fuck, you know. Maybe we shouldn't do Tara Kawas tonight. How long does this take to generate AI? Come on, AI. Keep it moving. Keep it moving. What? That's not Georgia Kappelman. Cool. Why does it think she's a doctor? AI, it's lawyer. Okay. What about a Simpsons character? Let's make her a Simpsons character. Doo-doo-doo-doo-doo. Yeah, everyone go to clipfly.com. Go nuts. Send all your creations into Discord. Link in the description to Discord if you're not on Discord. Whoa! Oh, I gotta save that. Oh, okay, that's enough of that. Oh,
We're both in the car watching her eating with the dentist, and Garcia wanted to, run through the patio and kill everybody on the patio, and Rivera talked him down, and they decided not to do that and went on their way. There was no confrontation. Lacoste hung out with Charlie later in the hot tub that night, and there was no mention of it. The defendant even told you herself that there was no confrontation other than the jet ski incident that occurred on July 1st. So I thought, well, July 1st, that's when Sigfredo Garcia tries to confront the defendant and Charlie Adelson as they're backing out to go jet skiing. And he's making a scene in the street, and Charlie Adelson refuses to engage and edges around him, and they are able to drive away. That is the same day, July 1st, 2014, is when Garcia attempts to call Charlie Adelson and gets Harvey Adelson and leaves that voicemail. So that's when the confrontation occurs, although they don't really get face to face because Charlie's in a car the whole time. The problem for the defense is if Garcia and Charlie struck up this deal that they told you about in opening statement, whereby Charlie, it goes from, I'm going to fight you because you're sleeping with my wife, to I'll do a murder for you for $100,000 if you'll leave my wife alone. If that happens on or about March 11th at the dinner meeting, then it doesn't make sense that he would make this deal with Charlie, go to Tallahassee in June to stalk and or kill, and then July 1st not know how to get in touch with Charlie Adelson. So that's the problem. Doesn't make sense. He's looking for Charlie Adelson. He doesn't know how to get in touch with him. If he had this confrontation that resulted in a pact to do a murder in March, then he would already have Charlie Adelson's information, be able to call Charlie Adelson and confront him after the jet ski incident. Wouldn't need
Fully compelling evidence, isn't it? She's doing a really good at just everything the defense has tried to do. Yes, he always knew about Charlie. He made a deal. He said, oh, blah, blah, blah. It's like, Judge has got this. Oh, wait until you see her rebuttal after Tara Kawase comes and embarrasses herself for an hour and a half. But I really don't think we can cover that today.
need to accidentally leave a voice message for Harvey. So that theory is completely speculative. It does not fit with the evidence in this case. All the evidence is consistent with Garcia traveling to Tallahassee. Remember, he's the one that rented the car. That car pinged in Tallahassee. And I would even take this analysis a step further and suggest that the fact that Garcia is trying to confront Charlie on July 1st, which is after that June trip, is evidence that he is walled off from Charlie in reference to this conspiracy. I don't think he's going to be trying to fight the guy that he's in the process of trying to do a murder for. A guy that's about to pay him $100,000 or his portion of $100,000 to do a murder 2 weeks later. This theory is further evidenced by what he told Rivera. He told Rivera they were coming to Tallahassee to do a murder so that the lady, Wendy, could get her kids back. Does that say 10 minutes? Mm-hmm. Oh, okay. I believe he did think he was doing this murder for a lady in Tallahassee, not Charlie Adelson, and possibly not even with the knowledge that the lady in Tallahassee was related to Charlie Adelson, the dentist. Regardless of how completely clueless she acted on the stand yesterday, the evidence shows that this defendant was not the pawn in someone else's scheme. She was not the pawn of two master manipulators. She herself was the stage manager in this thing. She was directing these guys. The defendant is guilty of everything she's charged with. You have all been so very patient throughout this entire process. And when you get back there to the deliberation room, I encourage you to bring your common sense with you. And you're going to need it to cull through all this stuff. The defense may ask you to speculate about things that are not in evidence. Don't do that. Remember that what the lawyers say, including me, is not evidence. Remember that you alone must decide what the evidence is, what evidence to accept, and how reliable the evidence is. They may tell you that just because all the evidence fits, it's not what it appears to be, it's really the opposite of what it appears, or that the state is blindly or willfully misleading you in some way. Please remember that your feelings about the lawyers should not influence your verdict at all. You should use your common sense in deciding based on the evidence and the law that the judge gives you. You decide what to accept and what to disregard. We are all trusting you to render a wise and legal verdict in this case, and I trust that that verdict will be guilty as charged. Thank you.
All right, thank you, Ms. Kappelman. Okay, we're going to take our morning break now. You can leave your instructions right on your chair along with everything else. And please remember, no discussing the case at this point. And we'll take a 15-minute break. We'll start back at 11 with the defense closing argument, okay?
I think we've got to leave it there, guys. Should we have one wiretap call to play us out? I just don't think I can do an hour and a half plus the 10-minute rebuttal. I'm falling asleep, which is probably a good thing. Let's do a wiretap. Wiretap. You see, now I'm going to get people in the comments. Well, why did you put Tariq Awas on the thumbnail? If you weren't, this is misleading. This is misleading to the viewers. You're a liar, True Crime Metrix. You're a liar. Fuck off. Like, give me a break. You don't know what it's like. Where are we? What are we doing? See, I don't even know what I'm doing. Media source. And then browse. True Crime Metrics. Audio files. Wiretaps. Okay, let's get something about 3 or 4 minutes. That should do. That should be sweet. 4:29. Let's do that one. Yeah, last call for coffees, guys. Last call. Or our goal. Have we still got time on our goal? No. Oh, we do. I think so. I don't know. Whatever. So this is from April 23rd, so post bump. By the way, it's the 19th today. Well, not anymore. Not unless you're in California. But yeah, it's nine years today the bump happened, guys. 9 years. Happy birthday, bump.
Hello.
Hey, what's going on?
Hey.
Sorry, I got your.
I didn't put the. Hang on. Media source. I need some volume.
Hello.
Hey, what's going on?
Hey.
Sorry, I got your. Nothing. I'm just driving to see my nephews. What's going on? Just driving to see my nephews.
Driving your jet ski?
No.
Oh, we did this the other day.
Miami.
Oh.
Stop. Stop. Hold. Different one.
Fucking A, bro. I'm gonna fucking fuck up whoever the fuck you fucking with me.
Hey, thanks so much, Kyle. Kyle Pariah. Thank you for the coffee, Kyle.
Hello?
Hello.
Yes.
You took care of the kids, huh?
I didn't take care of the kids. Tuto slept with the kids. Katie, how could you leave your kids?
I'm asking you a question, Mom.
Well, I'm asking you a question. Are you planning to leave the kids with Tuto forever? I mean, you're not planning to see your children?
Don't you think I'm asking you, did you take care of the kids? I know you did, because I know when they're not there.
Really?
And you're just doing it, and you're just helping him be a worse person.
Katie, you left your kids. When are you coming back? Are you planning to see your kids?
Of course, you don't think I miss them, but what are you going to do now? You're going to hang up the phone and call Tuto and tell them that I'm calling you? But yeah,
no, I'm not going to do that. I'm not going to tell them.
Why are you watching them? No, you're giving him a reason to drink and go out. He has a problem with drinking. Why can't you help your son out? And you're feeding into it even more.
Katie.
He couldn't take care of him because he was drunk all night. And he fights.
No, he wasn't. Katie, you're the one who started the fight. You and
I'm
him.
the one who started the fight. Okay,
Both
I was
of
the one
you.
asking. Because he's calling a girl at 3:00 in the morning.
Come on,
Oh,
a girl that is a lesbian and she's
So
like
what?
that
Hey, Nikki,
in black.
okay, Nikki's a lesbian.
Listen, Nikki's not a lesbian. I'm
not-
talking about somebody who has a
Nikki not
partner
have-
and she's black and ugly. You're
Did
jealous
you
of that?
know? Did you not remember who he was with? The prostitute who was a crack.
So now there's a black, ugly lesbian in this game. I mean, it's like,
Head, a snorted freaking white.
Katie,
And
listen.
freaking sold her.
What is the purpose of bringing out all this? What is the purpose?
But if you're enabling. Do you not?
No, you left your kids and you.
you're enabling, wobbling, enabling. What is it with these words of hers? You're enabling wobble, enabling.
You know, you left your kids, Katie. How could you do that? No mother leaves her kids.
Oh, no mother. I'm the bad one, but then the father can leave their kids, right? Because the father.
No, he never has, Katie.
Yes,
He's always been there, even when you're separated. Okay, listen. I don't want to fight with you. I just want to know if you're going back to your house with your kids.
Are you seriously gonna say that? That why? Because I have to. Now it's up to me, right? So that he can go off and do whatever he wants.
No,
whatever.
no.
But
Listen.
They took over your house. I know they did. Because I know
What? I swear on God that is not sleep in my house. Katie?
How all of a sudden, then that's quick. Then how come all of a sudden all of that stuff? Yeah. Always. Keep doing
I'm just telling you because I feel bad that you are not taking care of the
Then I
kids.
shouldn't be around my kids. I'm horrible. Then I shouldn't have my kids. You're right. I'm horrible. I shouldn't have my kids.
Okay, listen, listen, a mother is different than a father.
No,
a mother does not her
You
kids.
said it yourself. You said it yourself. I'm horrible. So
whatever. Are you going back to see your kids?
Don't worry about it. What does it worry? I told you not to take care of them, and you still do. So your son fucking fucks other people, and then you fucking drinks. Good job.
That's not right.
Good job.
Katie.
Wow, I hadn't heard that one before. Jesus. Wow. She's got problems, huh? Fucking hell. Okay, one more. Now I'm getting into it again. April 12th.
Yo.
Oh, I gotta spit.
Huh?
I gotta spit this loogie.
What?
I gotta spit the loogie that came out of my mouth right now.
Ew. Well, why are you telling me?
I don't know. What are we gonna eat for dinner? What are we gonna eat for dinner?
I don't know, man. You wanna cook? Cook it. Let me take a pasta. It's easy, man. Get the angel hair pasta. You gotta boil the chicken.
Oh my God! Why are you saying this out loud? Like, if I don't know how to cook.
Oh, damn. Nobody's listening. Everybody's on the phone. Nobody's listening to me.
Katie doesn't know how to cook. Is anyone shocked at that?
You gotta pass the chicken really quick because I want to make money.
Katie is sleeping with Charlie, but pissed off if Sig is with someone else. She's pissed off if he jerks it in the morning. She considers that cheating.
I got it.
You gotta pass out the what?
Victoria's Secret. Been wanting to go and the thing is higher.
It's 4 o'clock, bro. It takes forever.
No, I'm not. Leave me alone. What? You took forever in Men's Warehouse.
So you're not.
You can't hear me. I can hear you. Can you hear me now?
Yeah, I hear you now.
Okay. I thought I passed by Yanjo's job because one of the realtors needs a part-time assistant. And I was like, bro, I'll do it. And then
I better not be no young, good-looking guy.
No, they told me he's an old guy, like a Russian or not Russian, but he has like so Eastern, like he could speak English, but he doesn't, it's not clear. Can you just be happy? At least if I can get some part-time, I can have some income.
I'm happy.
Please. The kids wanted you to pick them up.
What?
The kids wanted you to pick them up, but I'll get them.
Pick up the kids.
But they wanted you to get them.
Yeah, it'll be okay. They always want you to pick them up every
They're
day.
sick
So.
of listening to you whining.
Yeah, well, now they're asking. You always get to freaking buy stuff. I'm never doing anything.
All right. Gotta go. Bye.
Okay, we're shutting it down, guys. I gotta go. I'm gonna be out like a light shade. Thanks so much for coming, guys. Thanks so much to the commenters, the supporters, the moderators. We'll be back. We'll be back. When are we back? Well, I guess we've got to finish this off tomorrow, huh? But the good news is, I think tomorrow, now, we could do Tara's closing, George's rebuttal, and then I don't know what's next. I think we've got, obviously, the verdict. Off the top of my head, there's a pretty interesting interview with Tara Kawas outside the courthouse. And sentencing, right? There'll be sentencing as well. Could we cram all that in one show? Maybe. And then we can say goodbye. Goodbye. Finished with KD2. We went through the whole entire thing. Man, it's been I feel like we've spent too much time with these people. Oh, yeah, we're going to be moving on to some non-Adelson criminals after this, guys. I'm looking forward to it. You should too, because it's going to be great. Subscribe to the channel, like, share, leave a comment. Yeah, no. Great job, guys. Great job, everybody. And have a pleasant evening or morning. True Crime Metrix out. Thank you.